Gentlemen, we will finally hearing matter. 7 to 12, 13 to 18.
You are not? Or transfer the appellant. When you submitted that then transfer the appellant not feeling well, post that to be Girimalaya. It is the inconvenience to the then transfer the appellant. Post next day. It's like
41, 42 to 45.
it's common.
Number 1. So judgment, serial number 1.
Well, kindly pass it over at 2:30 because I have to attend. I have to attend and moved matter before the quota number 4. Well, my submission is only to a limited extent. That the
No, that is the one is on driving
order
license.
of parent.
Yesterday you argued, I understood. Now the second aspect is about the enhancement.
Enhancement to future medical expenses, as I noticed now, 25, he required another surgery. For that,
Future medical expense.
And as far as a disability is concerned, the doctor, according to doctor, there is a two types of disability. One is the 33%, and for another limb it is 39%. Tribunal has considered 10% whole body disability. Loss of immunities, no compensation is awarded. And the total fracture is fracture of right femur, fracture of right patella, fracture of tibia, and Lisfrancis injury. That is a small fracture associated with disruption. That is also, he underwent total 2 surgeries and required one more surgery for removal of implants as well as for some other injury. So, my respectful submission is pain and suffering, loss of immunity. Loss of immunity, no compensation is awarded. Pain and suffering, only 25,000. Loss of immunities. Medical expenses as produced, that has been awarded. I have no grievance on that point. And next is future loss of earning and future medical expenses. My presence may be dispensed with, Suppose if I will try to attend. Suppose if my matter is reached in quota number 4.
No. You don't have to. You go to the other court. Yes, Mr. Lingraj.
Yes.
Now on the point of this.
On the question of
is the court audible?
Yes, I am audible. Only at the question of my lord, by yesterday, my learned friend was telling that Bhaskar was driving and he did not. No, Bhaskar was driving. He has been charge sheeted, and on this aspect, they themselves call upon examine the RTO official. They themselves examine RTO official.
Some vibration is coming. One thing, the other, all other things with muted. And the motor. Huh? Third. Yes.
One Bhaskar was driving. They themselves examine an RTO official. The DL extract is marked as Exhibit 315. That shows that the RTO examined by the claimants themselves shows that it was not issued to Bhaskar Murthy. And I have also produced exhibit R2 endorsement, and it is in Kannada, which says that no such driving license has been given to Bhaskar.
Sir, yesterday we have seen that there is no driving license. If there is no driving license, what should follow is the question.
Yes, my respectful submission is pay and recovery may not arise in this case because I have successfully proved, and it is a willful violation on the part of the insured. And para 84 of the
Let's
forensic
see
case should
again,
prevail.
584, give us forensic case. Keep those with you.
As your lordship yesterday court observed, at the end they discussed, but at the end the result is something else.
No. What do you say about the old 149 and the new 150 provision?
No, that has been considered 149 only.
No. Issue is no in the full bench judgment.
Earlier, yes.
It was considered there. It was considered. That's how the full bench said any kind of violation, pay and recovery will apply basing on 149 and or the new provision 150. That's the only provision which makes you liable.
Yes,
Violation
yes,
of policy.
yes.
So, because taking a clue from that one passing remark in Swaran Singh's case, all the while we were holding that valid driving license and no driving license.
Yes,
So
yes.
it doesn't make any distinction between because the very same learned judge who was part of that Swaran Singh's case, next in Pappu's case also, in so many words it was said that that will also apply even for in case of no driving license also.
Yes, I do have to concede that there's some anomaly in this judgment. Anyhow, your lordship has reserved the other matters. This also can be tagged along. And what the
This
court
also
decides,
along with it. Now let's come to the
Enhancement.
compensation. And he was saying about come to issue number 2 that we will discuss, and I will also reserve this along with that batch.
Yes.
That batch is there, no? About you remember the numbers? Post this along with it. One batch is reserved with regard to this driving license and pay and recovery issue. So this also be tagged on to that thought. Yeah. Please come
The accident is of the year 2010.
to.
He has suffered fracture of femur and 25,000 is given. I think considering the year of the accident and the age of the claimant,
How many are the injuries?
Pardon?
How many are the injuries?
The injuries is fractured to femur and he says that there's my learned friend was telling that there's a Lisfranc fracture. I don't know what was that he meant.
May I submit my doctor evidence? May I submit my doctor evidence? Very short submission.
Yes,
No,
your presence is dispensed with. So now the court will not carry you.
Total 4 fractures, Miller. 4 fractures.
Where will you get it from the order?
It is found in sorry, Miller. It is
para 11 of the judgment.
Para 11. What do you say about the disability? The doctor says that 33% and 39% at para number 12.
Yes, that is there. But the considering that one limb, it will be 10%, and it comes to 69. The 1/3 will translate it to 20%.
Let's say 20%.
Yes.
Disability at 20%. And what about his the salary?
As per chart, 2010, 4,500.
As per chart, 4,500 is taken already. He says it's a private.
Yes, 4,500 into 12. What is the age?
It is, he is a 40, then 15 is the multiplier. 15.
Huh?
15 is the multiplier. 15.
Into 25. 1,62,000.
1,62,000.
Then next,
Medical,
Pain and suffering, my lord. Pain and suffering, fracture of right.
medical
femur,
expenses.
as it is, that is correct, my lord.
How
That is
much?
correct. That is 1,12,333.
1 lakh?
12,333.
1,12,333.
I have no grievance on that point. Future medical expenses as per doctor evidence.
Let's just wait. The court come to that point. Loss of earning.
3 months is
3 months
considered.
It is considered
Reasonable.
reasonable.
Reasonable, my lord.
It can be retained.
Pain and suffering will grant 40,000.
Right, the total more than 3 fractures. It is left to the
40,000.
court.
Attendant pay this
11,
transportation,
total 9 days seems to be correct, my lord.
transportation and
Le-
extra nourishment 10,000 altogether.
11,000 plus conveyance 2,000 is already awarded.
No, how much it is? 5,000 plus
And 6,000.
Plus 2,000.
That
so
may be
2,000.
written.
Court has granted 6,000.
Yes.
4 plus 2
Nutritious
6. Now this court
No,
is
no.
granting 10,000.
No, nutritious food only 6,000 is granted.
Huh?
Under the head of attendant charges and nutrition, 6,000 is granted. And again 5,000 is granted towards nutritious food. Again 2,000 towards convenience.
So how much?
Para 18.
6,000?
Para 18. Para
30,
18.
5,000. No, 1 minute.
6,000.
11 plus 2.
13. 13.
13.
Yes.
Reasonable amount for that time.
Yes.
So will 13,000.
And future medical expenses.
Now come to the future medical expenses.
Future,
According to the doctor, how much?
25,000.
10 is the accident. He would have undergone. He has not produced any evidence.
How much was granted by the court?
No, nothing is awarded.
Will grant 15,000 for the future medical expense. Altogether, it comes to legal expenses and 60,000 plus 1 lakh. There is some disturbance call. What is the sound? No, from this here. You get a sound, no? It comes to 3,65,000.
65,000.
What was granted by the court below?
The total 2,44,935.
2,44,935. Now, I am also reserving your case along with it, with this calculation. Reserved
Interest 6%.
6% in all the cases. Reserved along with the batch. Yeah.
Much of
Bill number 2, original bill.
I think the list is also. Yes,
Bill number 2. Harish Kumar NC.
you will find.
Bill Loud Mariappa for respondent.
On 21/9/2023, this court passed docket proceedings will start. And these matters were posted on 29/2023. There was no representation. And even on 21/9/23 also, there is no representation on behalf of both the parties. The matter was directed to be listed under the captive for dismissal on 23/9/2023. On 23/9/2023, the matter was adjourned at the request of learned counsel for the respondent. Today, the matter is under the caption for dismissal. Today, also, there is no representation on behalf of the appellants. It appears that the appellant is not interested to pursue the matter. Accordingly, appeals are dismissed for not of appeal.
One of it, Pawan Chandra Shetty.
Yes. The request of, at your request, it is adjourned. That online, you were online, I think, yes. Hmm. When it will happen is interim order merging with the final order, that will happen when you file an IA. And immediately after the orders are passed, and even before you have an occasion to question it, if the judgment is delivered, then you will get an opportunity. In this case, at an earliest point of time, that because no, it is not in this case. It is like if this kind of view is taken, the things can never be settled. No, that was no everything that was done based on the legal question at one point of time. You can't undo it now. What were you doing? It is not about the litigant has to be vigilant.
Now the question is very clear. Now, one the 41 day says, if the two parties are trying, not that convention being taken in the now, this is what.
So I'll give you an example. Now you filed a suit for injunction. You wanted it. You filed a petition seeking amendment from one from injunction to a declaration. Court has permitted. Then you have let in evidence. Suit was decreed or dismissed. Now, according to you, in an appeal, so the court has to see whether that amendment was right or wrong. Is it what happens? Now the court will decide about the merits of it, not about the amendment, whether it is right or wrong. If that is the case, then that's civil cases forever will be pending. Now, whatever the CPC interpretation we are doing, already it is messing up things. Now we can't stretch it to that level.
It cannot be converted. Also cannot be. One of the matters I could not lay down. Sorry. This court has to tell you, even if there is the allegation in if the other side demonstrate that the income is more than 1,000, then the petition goes.
That is clear. No. All those issues are clear. Now, this is not your appeal. This is his appeal. Even your submission relying on a provision of the CPC saying that you can contest it. if it is your appeal, at least it has some legs to stand. This is not even your appeal. Huh? Oh. If it is correct, no, it is not open for you to raise that ground.
What I said, it could not have been converted. That is the ground, the new paper is not a matter.
Then why did it permit in the first place?
But the life committee and my.
What I expect from the advocates is you're appearing for the respondents. I understand that. You're an officer of the court first. No, in this matter also, I expect you to be more fair.
But I try to find out that very different really I mentioned to us. Even now that I prepared.
No, only one thing. Now, when the court has permitted an order is passed, amendment as long as back on, so now is it open for you to contend or for the court to say, then if it is not permissible, why did it allow?
That order itself was better. It's really because we start opposition to the not good line. The judge, the calculation only correct mistake that it has made. Assuming for a moment that it has only corrected its.
Oh,
It has
no,
not.
if the court starts correcting, do it today, tomorrow, correct it, day after tomorrow, take another view. Is it the law?
I would say that assuming that it should not have been done. Because it stands straight against the.
Now, this conversion of 163A, there were several divergent views. And even this court in that some stage has also taken a view that it is maintainable. Some judgments are done to that side and this side.
On the day the effects for deliver the different. From that day.
No, you are saying that this is the law. The evaluation of law is it's happening on several. So
The Lord said we are office of office. You also. But unfortunately, there I have one for judgment, one from Karnataka, and I was one from Madras. And I have one from.
those judgments are not at all required. You have to address the court. You have to address the court on the issue when the court has permitted them and when it has attained finality as far as that application is concerned. Now, how the court can say otherwise after that? That's the only issue.
Very common.
We'll have it on Friday for judgment. Let's not, whatever you want to make, you make, I'll pass orders. You can test it. No, because court has lot of other things to do. Give the docket. From how long the court is hearing this matter? So court has no time for this case alone. And it cannot, it can't be adjourned like this. No, I started hearing this case from 31/7/2023. I came here on 28th. From there, I've been hearing, these are the docket proceedings. Monday, finally, Monday, whatever it is, either of you, that day I will hear afresh and on Monday we'll pass orders. Not more than that. Yes, next. Which case?
Serial number 4, my lord.
Who is appearing?
I appear for third respondent.
Who is also here? What is his name? Passover.
Well, I am for the petitioner appellant in this case. In this case, I have filed a fresh memo of
Number
dispensation. Please, my lord. I have filed a fresh memo of dispensation for
Hmm.
R2.
Who is
Because there is
R2?
owner of the vehicle.
Insurance
And-
company was held liable.
Yes. There is no
And
dispute
why
on
is this
liability.
memo for dispensation of notice to R2 is returned with objection?
I filed a fresh memo to that effect, my lord.
Where is it? The memo is filed for dispensation of notice to the owner of the vehicle. He submitted that the court below has already held that the insurance company is liable. Accordingly, one memo is taken on file and the notice to the R2 is dispensed with at the risk of appellant. Yes, argue.
My lord, this is a case of injury. While the petitioner was walking, and he was hit by a JCB.
Huh?
He was hit by a JCB. And the petitioner suffered.
Serving of notice in a 2020 matter, at 2012 matter, I don't understand. He says that you are not served the notice. What is that?
No.
Serve the papers on them.
Mr. Pradeep was instructed to take notice on this particular matter. My
You
lord.
serve?
No, I have been appearing recently. I'll check on that and answer a copy of it.
You have to check it. Already this matter come up on the yesterday or so.
Yesterday it did not reach me, lord. I was there online.
I don't expect advocates to say that in the 2012 matter, they have not served notice on the other side. Who posts this matter on Monday? By the time if the papers are not served on the respondent counsel, the appeal will be dismissed on that ground. Next,
Hearing number 6, N. Krishnaswamy.
no representation for dismissal. Yes, post for dismissal tomorrow on behalf of either of the parties. Yes, Mr. Umesh, you're ready? No, no. If you have gone through it, please assist the court will dispose of. Because court can't wait for them to come. Yes.
Play home. ಮಾತಾಡ್ತಾನೆ in serial number 3, my lord.
It's over long back.
Sorry.
What happened to serial number 3? Monday.
So it's posted for Monday, sir.
Thank you. I am obliged. Sorry, my lords. There was some technical snag. I could not log in.
Yes. It's a case of injury.
Yes.
How much was the claim?
The claim was
3 lakh? How much is awarded? 99,500. Why you were exonerated? Your appeal is also there now. No, let us see, where is that order, remand order? No, it says the learned judge might have recorded in this order, will say. No, it is, if it's a vehicle is involved in the accident, whether it's a course of employment, either you can go before the Workman Compensation Act or before the motor, he cannot claim under the fourth act. Is it not?
Yes.
No. No. For example, he will become a third party, that employee, the workman or whoever it is. Now, a particular vehicle is there, when there is a use of vehicle. And because of the use of the vehicle, accident caused. Somebody was like unloading or loading, and suddenly the driver has reversed it and the accident has occurred. In that case, even though he's an employee of that person, because the vehicle is involved, either he can go under the Workman Compensation Act or under the Motor Vehicles Act. And but he cannot have under both. Let's see. On 11/3/2009 and about 2 p.m., the petitioner was unloading the stick wood lorry near so and so. The driver of the said lorry drove the same in a rash and negligent manner with high speed, endangering human life and property without observing the traffic rules and regulations. Held down and sustained, so and so. Let's see where your that para of it, where you are exonerated from the liability. In the first round of litigation, what was done? Oh. Para? Para 21.
Yes, reported the January 16th. Information of all relevant in the agreement. But in next year, the complete book of was not required to be provided, nor the engineer is specifically covered. Information of all relevant.
So the court holds that MB Act will not apply. How often it be? Isn't it wrong?
No, that is why I said, statutory liability, the one employee is also statutory liability. It is the act policy.
No, policy doesn't matter here because it's a third party. He's not traveling. He's not traveling. He's not traveling in the goods vehicle. But when he was loading and unloading, because of the negligence of the driver while reversing the vehicle, it hit him. So there is use of vehicle. Once there is use of vehicle, ME Act will apply. You can understand he is traveling or some other things. No, if you see how the manner of accident. The brief, no, let's see. The brief facts of the case are that on 11/3/2009 at about 2 p.m., the petitioner was unloading the stick wood in respondent lorry near so and so. At that time, the driver of the said lorry drove the same in rash and negligent manner with high speed without observing the traffic rules and suddenly moved the vehicle and the petitioner fell down and sustained. Let's forget about whether he's an employee or not. As far as your policy is concerned, he is a third party to the policy and there is negligence on the part of the driver of the vehicle. Why wouldn't he be covered under the MB Act?
Assuming whatever he does, we are going to cover what is the cleaner in the body and the other surveillance. It is the certificate. For example, if it claims that it was invalid case, comes as a cooling or not, if it does not claim that it is employed the garment, then possibly not get the right.
Subject to correction, the view of this court is whatever he claims, that because of the negligence on the part of the driver and use of the vehicle, accident had taken place, either he can come under the MB Act or the Workman Compensation Act is his duty. And if he once he makes an application under one, he cannot maintain the application under the other. But yes, Mr. Krishnaswamy, what do you say on this? Now, a person, according to the court did was, he is an employee, is an employee, loader and unloader. And while he was loading and unloading the goods, because of the regulations on the part of the driver, I hit him and he sustained injuries. Now, the court says, because he's an employee, workman, he has to go only under the Workman Compensation Act, but not under the Motor Vehicles Act. That's what he said. So, 21, let's see. Let's see. There are judgments of the Supreme Court. They have far-fetched definitions are there.
It has been made clear that only those persons who are workmen are required to be covered more than individual. That is not the code.
What I'm saying is, the code is saying that because your policy covers the workman, on that basis, you are not directed to be paid the compensation. Here, he is a third party to the insurance policy. Why can't that be, that analogy will apply? No, he may be working, still the MV Act will apply.
That question may not be done. But the relevant question may not be, everybody says, what is being shown in the public policy? You have to have one ability for a collaboration.
Pick up.
Employee of the line.
Still,
And that is why what was it?
Still. he is an employee of the lorry. Still, what was he doing?
Rolling the line.
No, if you say, no, he was sitting in the lorry and the lorry was moving, some accident had taken place. According to you, no person in the lorry, they have not paid any premium. Person who is sitting in the lorry is not covered. I can understand what is happening. This has not happened while you are sitting in the lorry or when you occupied the place. He was on the road. He was loading and unloading. In that case, then you cannot, he's a third party. He's a third party. You don't have to look at judgment for that. Huh? Maybe. No. Let us assume that, it won't come to an end. Let's assume that he's an employee. Now the question is whether he can make a claim under the Workmen Compensation Act or under the Motor Vehicles Act. Then the judgment of the Supreme Court is very clear that when there is a use of vehicle and in that case, and an accident takes place, it is for the employee either to go under the MB Act or under the Workmen Compensation Act. You cannot compel that because he's an employee, he should only be compensated under Workmen Compensation. There are judgments to that effect, and even they are very far-fetched judgments. So Supreme Court judgments are there. What they say? Huh? No, that's what I'm saying. Now, if as per the policy, these many people like the employees, one employee, two, and whatever the coverage is there, it will be covered. Here in the case, because of the negligence on the part of the driver of the vehicle, accident has taken place. That person is a third party to the insurance policy.
It's called. Required to be covered. Exactly. Certain risks are required to be. Those persons with risk are covered. The parties as well.
Now, under 166, to maintain an application under 166, what are the ingredients to be satisfied by any person, by the claimant?
After 166 is concerned, it is not be a third party, be a policy.
So let us forget about not the third party. No. Once you file an application of 166, what you need to prove is there is negligence on the part of the driver of the vehicle. And if you're claiming insurance against the company, that vehicle must have been insured by the insurer. These are the two requirements. No?
Yes. Accident as well as liability and insurance is concerned, the criteria would follow.
Hmm.
It's just be about academic complication.
But that is true. Yes. According to me, in the facts and circumstances of this case, 100% you can maintain an application under 150, not under the workman compensation. No, he can maintain workman compensation act, but you can't compel him to only avail that. So what the court said ultimately, hence respondent number 2 is not liable to pay the compensation. Accident occurred after so the citation applies so and so, he comes under the Workmen Compensation Act, but not the MV Act. Let's see. Oh. 160? Yes.
Often regarding clients for compensation. Understanding anything contained in the Workers' Compensation Act. When therefore, or already lead to the person who is essentially applying for compensation under this act. And also under the Workers' Compensation Act. The person entitled to compensation may, without prejudice to the provisions of Act, claim such compensation under either of those acts.
Under the both. Under both the acts. So under ESI, there is a bar. If you have employees stay in section 53 of ESI Act, says you have a thing, you cannot maintain an application under the MB Act.
Same amount compensation will not be granted. But in the India,
Correct.
it covered.
Correct. So we'll post this matter on Monday, but the courts, but as of now, the view of the court is it's maintainable. And if you can convince the court, we'll see. Post on Monday for judgment. There is no representation on behalf of the appellant, then comes for the respondent present, heard in part. Yes. Serial number 8. On matter. Call is matter, no? So Krishna Swami, you are ready with item number 6? Call the matter. Rest of the owner. How much was the amount claimed? Claimed. How much was awarded? 3,76,912. What was the age? Yes. Up to occupation, milk vending. Hmm. Hmm. Yeah. No, it's a act policy or a. No, in the package policy, all the inmates, for example, car, all the inmates are covered. The same thing applies to the two wheel. No, he's a filling rider. No, before that, what are the IRDA guidelines with regard to the? No, basing on the guidelines issued by them, several cases are withdrawn by the insurance companies with regard to this coverage of the persons inside the act policy and the package policy. In that, in that. Hmm.
Satisfy this one.
So, and even if the pillion rider if the pillion rider is not the owner, then you would be entitled.
Also last around 120.
Now this Ram Kiladi case will come into play. Ram Kiladi's case will come into play. No, about the personal action committed in the dispo of owner. Hmm. Now, which provision you are referring to? 140?
What is the?
Hmm. Any liability.
These are the continuing. Roman 1 and Roman. It's anyway, maybe that's how our body any color. It's important to say that it's one thing, including more of the goods or is authorized relevant to carrying the data are damaged to any property of the third party or higher. Passenger The public service payment. This was the point that we were cannot be voted. Payment card is not a public service. Therefore, this is not assumed in the current loan card. Where raising over to the later.
I think it's a new one. Act of 1980, 2022, amended act is there.
Notwithstanding anything contained in any law or the any code. An insurer is giving a policy of insurance and the section can be able to indemnify the person for the purpose of paying the policy purpose to cover in the case of that person or those
Why that, no, that is omitted in the latest one.
is there. Instead of five, and made a four.
Notwithstanding anything, a policy of insurance insured for the commencement of the shall be continued on the existing terms under the contract and the provision. Or not. That is 6 now. 147, 6 now. 148. No, you are saying about the judgment. Balakrishna's, that's here, that's here. Balakrishna and another.
Maybe it's not a.
That is with regard to the act policy and the coverage of inmates. In act policy, they are not covered. In a package policy, they are covered. That's what the. I had. Oh, that will be one.
They also.
Hmm.
This is not covered. Person will be.
Pillion rider is also there. Liability of insurance company.
It can be used for hiring or report. Or risk of an employee in academy.
No, earlier your stand with regard to the pillion rider was because it's an act policy and pillion rider, no premium is paid. So we don't have to pay the compensation was the earlier stand of the insurance company. After the ARDA guidelines, I think that was also covered. Package policy, that's what it is. Covered.
Package policy. Quantity. The land report. One person is taken for even these are the three things we do.
Circular is of 2009. 2009 circular, IRDA. Yes. Under which terms or any policy which covers the owner? He also should have, some, should be. Because in these days, that 1 lakh, 2 lakh, the personal accident coverage, which was started probably in, no, in a general, for example, a normal four-wheeler car for the personal use, owner will be driving most of the time. If the accident takes place, his ticket increased, should be increased, like how the Madras High Court said, he should keep on varying basing on times and the money, the value of the money and all. That 1 lakh, 2 lakhs, because they're long back, how does that money will matter now? And paying 400 is not a big issue for the. And in that, no, because of that, the insurance company will be very stingy and strict while giving the money.
They are told our maximum number of risks, potential risks are. It will not be exceeded. But two We explain to each one of them because of these two. But yes, other things are also there that more number of cases, momentum cases
No, this motor accident insurance, and these insurance policies on one hand, no, they have this medical insurance. They don't even tell the customer what is that he'll be entitled, what he will not be. Happily, they'll give him a green picture and tell them that and this and take the money. No, really, when he is in need and when he joins in a hospital, you come up with 101 things that this is not covered, that is not covered. Now everybody, whoever lives with that calculation and all, this insurance companies and the money is a public money. Why can't you be more transparent where in this process, that's what happens. They will get with all the collusion and all. And the genuine person, where will he go? The suffering loss. I think in the recent past, I have heard it.
Because the insurance company have collected billions. So the 2009 risk is covered. But in 2023,
And apart from that, the insurance companies also, for the sake of filing appeals, you will be filing the appeal.
not for the sake of no, whatever happened, you getting now. People can take has to be part of the idea of it. There is and they will succeed.
In Andhra Pradesh, I have seen, in Telangana, no, in Telangana also I observed, in 90% of the insurance company, at least here I see that there is some point in majority cases. In Telangana, all insurance company appeal. No, there won't be any point at all. Just like that, they'll file the appeal. That's what I'm saying. Why are you filing the appeals and why are you depriving a person who is in need of money by paying? What they want is at that relevant point of time, half amount to be deposited. Now we are relieved of. But now they have realized, now they stopped, very few appeals are being filed. But now they understood that, in this, in their pursuit to delay the whole thing and deposit the money, when some order is passed, all the interest and all, it accumulates like anything. So now they are conscious of the interest part. Yes, sir. Not for an insurance company, which is a. No, that's why what I told the registry also there in Telangana also. I want the insurance company appeals and a priority so that they can be disposed of so that the claimants will get the money what they are. So now also I told them, when I asked the list, I said insurance companies appeals to the, so that 50% amount that the claimants will get. If their appeal, they might have realized the amount by this time. In your appeal, 50% amount would be there, like, it will be in deposit and 50%. What will happen there is, no, at the time of granting the order itself, they'll give it. Saying that insurance company shall.
Major issue by most the senior.
50%, and the claimant is entitled to withdraw the amount. That would be general order in all the cases. So coming back to this, now let's go to the finding of the tribunal. What did the tribunal say? Para number? Yeah.
Yes, contention taken by the respondent is that they are not responsible for the total appearing they upon we are before Vinasa said that insurer can become owner. Just getting into his own negligent driving. Insurer is not liable to pay on. Another violation is what the insurance company is liable to pay for injuries over and that water is not.
Now please come to para 17. Para 17 on the chapter.
This case, on the nature of accident, it could mean that it is not done. Actually, very insured. In this case, the petitioners are claiming compensation after the death of the insured. Or this owner of the vehicle is possibly for.
What is this IMT 5 and 22? Is the policy? Let's see what is that. Any accidental IMT endorsement 522. IMT 5 is hire purchase agreement. Agreement hire purchase agreement. This for 22, where is 22? IMT 22. It's about liability to third party, loss or damage to the vehicle insured. Then IMT 22, compulsory deductible. Which is kind of policy. Probably the manager felt that it's a case of death. That's what we can understand from the observation. Also, just said that 5 and 22. And where will you get the PS, personal accident coverage? No, 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 no. Here, from the policy. Hmm. For the compulsory coverage. Hmm. Personal accident coverage for owner, driver. If somebody else is driving, he'll enter into the shoes of the owner and he'll get 1 lakh. Hmm. Anyhow, now anyhow we have been there, we are reducing the amount also, that's not possible. This is an appeal filed by the insurance company, agreed with about past in NBC number 217 of 2009, dated 23rd June 2011. The claim petition is filed, seeking compensation of an amount of rupees 7,50,000 for the death of the deceased in the accident that took place on 10/12/2006. It is a case of the claimant that the deceased on 10/12/2006, when he was coming back from Bhadravati after supplying milk to his customers, the first respondent met him on the road, and as he intended to come to Masrahali, the deceased allowed the respondent number 1 to drive the TVS moped belonging to him. The first respondent drove the TVS moped in a rash and negligent manner, which met with an accident near the house of met with an accident. Immediately was taken to the hospital at Bhadravati, then to Enhancement, Bangalore, where and when he came back to home on 17/12/2006, he died. It is a case of the insurance company that he is the owner of the vehicle, and the insurance policy is assured to indemnify the owner in respect of the any loss to a third party, but not to the owner of the vehicle. And they have relied on several judgments of the apex court that the insurance company is not liable to pay the owner of the vehicle. The court below had observed that on perusal of the nature of the accident, it would be seen that the accident has not done due to the rash and negligent riding of the insured. To stop. The claimants are claiming compensation after the death of the insured. As it is a case of death, though deceased is the owner of the vehicle, as the policy shows that it covers IMT 5 and 22. 22, the court came to the conclusion that the insurance company risk is covered as it is a package policy. And granted compensation of an amount of rupees. How much is the amount? 3,76,912 was granted. Agreed thereby, the insurance company is before this court. Then counsel appearing for the insurance company submits that the deceased is the owner of the vehicle, and the policy does not cover the risk of the owner. At best, he may be entitled for the personal accident coverage. The code below had relied on IMT 5 and IMT 22, which do not cover the risk of the owner of the vehicle. It is submitted that he has relied on section 147 of the MB Act and submits that the risk of the owner is not covered under an insurance policy. He submits that the code below, without considering any of these aspects, had granted the compensation. There is no representation, there is no representation on behalf of the opponent. The next para, having heard the learned counsel for the appellant for this entire material on record. Before going into the merits of the matter, it is appropriate to look at section 147 of the Motor Vehicles Act. Section 147 deals with requirement of policies and limits of liability. Section 1A, Roman 1, 2 reads thus. Extract that. Then 6, 147, 6 that you extract that I have. This provision makes it clear that the insurer issuing a policy of insurance is liable to indemnify the person or class of persons specified in the policy in respect of any liability which the policy purports to cover in the case of that person or those class of persons. As rightly argued by the learned counsel for the insurance company. The policy, as far as the policy does not cover the owner of the vehicle. And what is covered is the personal accident policy. The IMT 5 and 22, which the code below had referred to, the code had perused the same. Section 5, IMT 5 is a hire purchase agreement, and 22 is a compulsory, deals with compulsory deductible. None of these will come to the rescue of the owner of the vehicle. The considered opinion of this court, the code below ought not to have held the insurance company liable and ought not to have granted the compensation. So far as personal accident claim is concerned, a perusal of the policy shows that is entitled for an amount of fees 1 lakh. Hence, and insurance company is liable to pay the same. In view of the same, the appeal of the insurance company is partly allowed that if the claimant is entitled only for the PAC of 1 lakh, the personal accident coverage account. The amount in deposit shall be transmitted to the court below, and if there is any excess amount, insurance company is at liberty to withdraw. Next. Oh. Mr. Mahesh,
Number 4, is allowed money problem.
Mr. Mahesh. He has to be there, he's not there. He is muted the.
Oh, Mahesh, sir.
Just wait, if he comes online, we will take it. 2:30, it's already past 4.
Serial number 8. A. Ravishankar.
Yes. There's no representation on behalf of the both the parties. Post for dismissal tomorrow.
Serial number 9. N.M. Swami.
Same.
Serial number 10.
Yes, Mr. Krishna Swami.
A. Vishwanath.
Claim is 35 lakhs. $35 lakhs, 65,000. How much is granted? I think in Karnataka there is no court fees. That's why I always wonder looking at this claim. In the yes. In case of these injuries, we never see this lakhs of rupees. Maximum in case of death, probably I have seen dealing with this 10, 11, 12 matters, maximum was 10 lakh in case of death, the claim. Somebody was telling me in case of a pilot, they sought for some 1 crore or so, 1.5 crores. It's supposed to be more because they have to pay the court fees. They were not claiming more. This is a case of injury. No, what will happen is if it is a just and reasonable compensation. No, they pay in every order there what it would be like the points like what should be like the interest rate so and so the insurance company. One of the conditions there would be the claimant shall pay the deficit court fees on the enhanced amount. That will also carry. No, why not? No. Why not insurance company be paid? So you filed up, you solved everything till now. And why should they be deprived of? Hmm. So why not? Why you're not? Why you're not liable to pay? No, he is entitled. No. He is entitled for an amount as on this date. Now, it was determined for after 5 years. After that, why are you not? Who then? If you don't pay the interest, what will happen? Uh, I don't know. In Telangana, it is 9. Right, those days it was 9%. Because it all depends upon the bank interest rate as on that days. You cannot say what is today, what is in 10 years back. No, in those days, if it is 9%, for example. Hmm. No 150. Hmm. Right of third parties against insurance. That is 50, 150. Last portion, that is proviso 6. So in the same thing, 151. Hmm. Hmm.
With respect to liability, look at the rate, any amount payable. There must be some provision in respect of costs. Focus on made over except 72 capital impact. Any sum payable in respect of interest on that sum. Of any enactment relating to interest and benefits. There must be some enactment relating to interest and benefits. Therefore, only enactment is the 24. Some states they have changed it from 6, maximum 6, 9% and 8%. I think other states retain the same.
I never seen 6% in Telangana.
Thereafter,
The very same judgment where he have dealt with this consortium. The same judgment you're referring. Consortium. Here, Karnataka. Oh, no. And the court has granted 3,64,000. Now, please come to issue number 1. We'll see how the accident and the manner of it.
In the midnight year, and belonging to in from opposite direction, opposite side, that is not opposite. The rate of which disease runs up by very vigorously.
When was the complaint given?
On 3/3/2000.
Accident was on 3/3/2009. Complaint was on same day. What did they say in the complaint? 1:30 AM was the accident. Give the lower court record. No, probably even 1:30 also they are referring to second. They don't even say that unknown vehicle is a factor. Then when it comes to the MLC, that is exhibit. There is no MLC. Spotted. Then who are these witnesses? How is he related to the deceased? They're traveling on the same vehicle. What was he doing at 1:30? On the road at 1:30. Who appears for the respondent? H. Devendrappa. Appeal is dismissed as abated. Who is R7? Notice to R6. Anantappa. That's what. I think there appears to be something to be heard and counsel for the appeal. There is no representation for the respondent. Post the matter for judgment today after tomorrow. This is Mr. Ravi Shankar. Item 8 is yours. You are not Ravi Shankar. Yes.
So let us adjourn. Hearing number 12. It is Bandare.
I appear for the.
So ready?
Respondent. The claim petition is this insurance company has been exonerated on the ground that there is no insurance. Your lordship, the court may kindly
Something
recall
is
this
wrong
matter
with your
was
audio. You're not audible, Mr. Lingraj. Yes. What were you submitting?
no, this matter was heard long back. There was a discrepancy regarding the period of insurance coverage in the cover note and the policy. As of the date of the policy, there's no insurance. Policy does not disclose that the policy was valid as on the date of the accident. The owner is represented herein. Your lordship would observe that it would be better if the owner produces the says something positively about this. The tribunal has accepted my defense and exonerated me.
Exonerated on what ground? That there is
That
no
there's
policy
no-
as on the date of accident.
Date of the accident, yes, my lord. Yes, no policy as on the date of the accident.
No representation for the appellant, and counsel, respondent present, post this matter for decision tomorrow. Yes, like,
Can you repeat?
you see here? When do you want? At the request of learned counsel for the appellant, post this matter after 2 weeks. Yes. This is Peter Amaro. He was there in the morning. This is Sita Ramarao. They're disputing the involvement of the vehicle. We'll post it for dismissal tomorrow. Poses to no representation of the appellant. Counsel of the respondent is present. Post for dismissal tomorrow. Same for dismissal. Mr. Shastri, ready? Unmute your audio.
Kindly pass over, my lord. Kindly pass over. 2:30 I will come. Otherwise tomorrow, my lord. Otherwise
No,
tomorrow.
otherwise, so come at 2:30. Yes. Yes, Mr. Mahesh.
Yes, my lord.
You are ready?
The other side is ready, I am ready.
Even if other side is not there, we will hear. Please argue.
Yes.
Yes.
Appeal by the insurance company, my lord.
2 appeals are there.
2 appeals, my lord.
Common order.
It's a common order.
Let us look at the MBC numbers and the corresponding appeals.
Yes. My lord, MFA 8646 of 2012 is against MEC 837 of 2011.
830.
837 of 2011 MACT Bangalore. Then, my lord, MFA 8647 of 2012 is against MEC.
You already said 8647 first.
Pardon?
No, you said first MFA 8647
8647.
against MBC 837 of 2011.
No, MEC 1020 of 2011.
MBC 1020.
1020
Then
of
MFA.
only 2 matters, my lord.
Oh. First, MFA number 8647 is against arising out of MBC number
1020 of 2011.
and the second appeal is MFA 8646
8647 of 2012 is against MEC 1020 of 2011 MACT Bangalore.
Case of death or injury?
Both are injury cases.
How much was the claimed amount in MBC 1020?
10
20.
1020
Claimed amount is?
is around about 1 minute.
Yes. MBC 1020 claimed amount is 3,15,960.
Yes, ma'am.
And in MBC 837, 3,75,000.
75,000 is
How
the-
much was awarded
Right,
in MBC 1020?
1020, 3,15,960 with 6% interest has been.
Hmm. Now you are on what ground?
But on the ground, my lord, that the claim made against the insured vehicle is doubtful.
Hmm.
Since, my lord, they have not produced the relevant medical document where they were first treated
Hmm.
in Mathamshri Hospital, Nelamangala.
Hmm.
And they claim that both were walking by the side of the road,
Hmm.
and the rider of the motorcycle insured came in a high speed and dashed against them from behind.
Yes.
Now, my lord, I would like to invite your worship attention to the injuries, my lord, said to have been sustained by the two injured persons. One injured is Munegowda.
Now you are on quantum also.
I am on the 1 minute. my lord, I will- No, I am not on the quantum, Lord.
Yes.
I am not on the quantum. What I am contending, my lord, is that it is not proved conclusively that the insured vehicle was involved in the accident. And otherwise, they are guilty of contributory negligence.
Yes.
Well, now, you must kindly see the injury in case of Munigowda
Hmm.
is a fracture of both the bones of right leg.
Where will you get that?
That is
Now issue number 2 in MBC number 837 of 2011.
yes. Three issues are framed, one regarding negligence,
Para
another
number 15 you will get. Para 15.
para 15, my lord, I'll just. The injury which the petitioner had suffered, that is grade 1 compound fracture of both the bones of the right leg upper 1/3, which is grievous in nature, and he was surgically treated in Matrushri Hospital. In his petition as well as in the affidavit filed by him, in lieu of his chief examination, he has stated in para 5 that he cannot stand, walk, sit or squat on the floor. cannot lift or carry weight, etc. Dr. C.V. Kumar, examined as PW3, has clinically examined the petitioner and has found that the injury sustained by the accident, the patient is having difficulty in sitting, squatting, climbing stairs, and suffered disability to an extent of 45% to the right lower limb and 15% to the whole body. And the petitioner would find it difficult to stand. So, and he is a fitter, my lord, that is the case. Well, what I am understanding, my lord, I made application, my lord, under order 16, rule 1 and 2 of CPC to summon the Dr. M.V. Kumar.
Yes,
That was, my lord, rejected by the tribunal. Because he was the doctor, my lord, who, treated him. And I would like to invite your lordship attention to, my lord, the P1 FIR and the complaint by Munigowda.
Mm.
It is on 11/1/2011 at 2 p.m. while the accident was on 9/1/2011.
Accident on 9/1/2011.
Yes, my lord.
Complaint on?
Complaint on 11/1/2011 at 2 p.m.
Mm.
Then exhibit P2 is the wound certificate of Matrushri Hospital
Mm.
dated 12/2/2011,
Mm.
wherein it is shown that first seen on 9/1/2011 at 8:40 p.m. RTA with the history of RTA.
Mm.
Then, my lord, the Mahazar exhibit P3, two Mahazars, my lord,
Mm.
said to have been drawn on 11/1/2011
Mm.
and 19/1/2011.
Mm.
Eyewitness being Subhash Kumar.
Mm.
This Subhash Kumar, my lord, had not been examined,
Mm.
said to be the eyewitness. Then, my lord, exhibit P4 is the IME report,
Yes.
said to have been examined the offending vehicle on 24/1/2011 at police station.
Yes.
Then exhibit P5, my lord, is the two statements of Muralaya
Yes.
and Subhash Kumar, said to be the eyewitnesses, on 12/1/2011. Then exhibit P6, my lord, is the MLC intimation by Matrushri Hospital on 9/1/2011 to Nelamangala Police Station
Mm.
with RTA history. No vehicle number or type of vehicle, my lord, is forthcoming. The doctor examined, my lord, is one C.V. Kumar. And application was made by the appellant company, my lord, to summon him. And also the concerned medical officer to produce the medical document, that is the accident register extract. That is not entertained. But now I'll take your lordship through the, my lord, evidence of PW1,
Mm.
one of the injured.
Yes.
Para 3 of his examination in chief.
Yeah.
I submit that on 9/1/2011 at about 6:30 p.m. I was a pedestrian along with one Manjuna on extreme left side of the Chikkakanahadli, Madurai Road. At that time, the rider of the motorcycle twister bearing registration number KA04SC1154 came from our backside from Basava temple side in a rash and negligent manner, endangering human life without observing any of the traffic rules and regulations, and dashed to me and Manjunath, due to which myself and Manjunath fell down and sustained injuries. Myself sustained injury following injuries, so and so, so and so. Para 4. I submit that immediately after the accident, I was shifted to Matrushri Hospital, Nelamangala. First, he was taken to Government Hospital, Nelamangala, then to Matrushri, that is skipped matter, where I took treatment so and so, so and so. Then, Ballard, I invite your attention to cross-examination, bro. Type it page 6. The police had come to Matrushri Nursing Home, Nelamangala, and recorded our statements. One Muralaya had given complaint to the police. We have produced the complaint as well as statement to the court. It is not correct to suggest that I have given complaint to the police after 3 days, and in meantime, I have colluded with the insured and the police to fix the insured bike. It is not correct to suggest that false complaint is given against the rider. My maternal uncle had not given the complaint to the police on the same day. It is not correct to suggest that all the police papers which I have produced are created by colluding with the police and the insured, even though the bike was not at all involved in the accident. After the accident, we were taken to Matrushri Hospital, Nelamangala. The said hospital is about 16 kilometers away from the accident spot. Dr. Kumar had treated me in the said hospital. We were shifted to hospital in an ambulance. I had given the history of the accident and particulars of the accident to the hospital authorities. I have not produced the MLC register extract. It is not correct to suggest that the registration of number of the bike is not mentioned in the own certificate, and as such, the insured bike was not at all involved in the accident. It is true that the vehicle number is also not mentioned in discharge summary. It is not correct to suggest that I was not treated as an inpatient from 9/1/2011 to 31/1/2011. Then, my lord, the para 3. It is not correct to suggest that I have not spent so and so, so and so. That is the amount, my lord.
And cross-examination is, he has denied everything. What is the relevant portion you want to point out?
Then PW2, my lord, another injured.
Yes, I'm looking at his evidence.
Here. There you may kindly see. Then PW2, my lord, 1, Mr. Manjunath. There is some confusion in the.
Now, with regard to the accident, we couldn't elicit anything from him. And about, it's also more or less like PW1's evidence.
Yes.
Yes.
Then
No, say that there is a contributory negligence. Where is evidence letting?
my respectful submission, my lord. Both, my lord, said to have sustained, my lord,
Yes,
fracture of right leg. You must kindly, my lord, visualize. If both are walking, my lord, side by side or one behind the other.
yes.
If the motorcycle, my lord, come and dash against, my lord, these two people,
Mm.
then it is very strange, my lord, both of them get the fracture of right leg. The possibility, my lord.
Then
Therefore,
one should sustain fracture to the right leg, other to the left leg.
my lord, both of them, my lord, the right leg. You must kindly see, both are right leg, my lord, and forearm.
Yes.
For Manjunath, my lord, fracture of both the bones of the right forearm.
Hmm.
For Munigowda, my lord, both the bones of right leg. This is what.
One is arm, other is leg.
But what I am suggesting, my lord, whether they are walking side by side or one behind the other.
Yes.
If a motorcycle will come and dash against them from behind, these type of injuries are not possible unless they were crossing the road.
Hmm.
Therefore,
Yes.
the theory put forth, my lord, by the, my lord, the injured claimant cannot be believed in the light of the, my lord, the injuries sustained by them. Then, my lord, PW3, my lord, I'll invite your lordship attention to cross-examination of PW3 doctor. Page 4, my lord.
Yes.
I have treated the patient and also issued wound certificate. I do not know who had brought the patient to hospital. The history of the accident would have been recorded by CMO. The history is not recorded in case sheet, but it is mentioned in the MLC register extract. The said MLC extract can be produced before the court. Police intimation has been given about the MLC case. The particulars of the vehicle involved and its number would have been mentioned in the police intimation. It is not correct to suggest that the police intimation was not given and MLC extract is not maintained in the hospital. It is not correct to suggest that the patient had not sustained injuries in RTA, but falsely mentioned in the case sheet that he had sustained injuries in RTA. Exhibit P2 wound certificate and P19 case sheet does not contain the X-ray numbers. Patient has taken follow-up treatment after discharge, but I have not produced any documents so on. So it is not correct to suggest that the patient had not taken any follow-up treatment after 13 January 2011 since the fracture are united. It is not correct to suggest that that for the said reason I have not produced any document. Fractures are not united as on the date of recent examination. It is mentioned in the recent examination report that there is a delayed union. It is not correct to suggest that I have falsely stated that the petitioner has sustained disability of 45% to the right lower limb and 15% to the whole body. It is not correct to suggest that the petitioner does not require any surgery for implant removal at the cost of rupees so on. So this is the malad. They say that the radiological reports are also not produced. Then police intimation, malad, does not disclose malad vehicle number.
Did you suggest anything that this vehicle or the owner of the vehicle are known to the claimants?
Yes. Then, my lord, I'll invite your lordship attention to my lord exhibit P1. The Munigowda, my lord, he says that his uncle gave a complaint at Moraya, but my lord, exhibit P1 gives a different picture. P1 may kindly be, my lord.
Yes.
Munigowda is the injured, my lord.
Hmm.
And it was reported on 11/1/2011.
Hmm.
Then, my lord, the complaint, my lord, which has been reduced and signed by the my lord Munigowda, there you have kindly see at the bottom, my lord,
Hmm.
before Mathurshri Hospital has been struck off. And in the margin, my lord, it has been mentioned as 11/1/2011. 10 is made to look, my lord, to be seen as 2011. This is signed by Munigowda, but what he says in his examination chief, my lord, that he had not given the complaint, but he has, his uncle Mullaya and Subhash Kumar had given the my lord accident, who has seen the accident. Then the Mahazar, my lord, is said to be on 20th/11/2011.
Yes.
There you have to kindly see the date has been inserted and there is overwriting. Then interestingly, my lord, IME report
Yes.
is of 24/1/2011.
Hmm.
So all these documents
Hmm.
and the statements said to have been recorded, my lord, and they are taken to government hospital first. That, my lord, is not forthcoming. And the application made by the appellant, my lord, to summon Dr. C.V. Kumar and the officer in charge of, my lord, to produce the document, medical reports, was rejected.
Yes.
So, under these circumstances, my lord, my respectful submission, considering the nature of the injury, my lord,
Yes.
the tribunal ought to have, my lord, considered the contributing negligence, even if it holds that the insured vehicle was involved.
You can't take two inconsistent pleas. Saying
But-
that the vehicle is not involved if is your stand, then where is the question
Yes,
of
my lord.
contribution?
On the contrary, if for any reason, my lord, that court comes to the conclusion that vehicle is involved, then, my lord, question of negligence has to be, my lord, considered. There, my lord, my respectful submission is the nature of injuries, my lord, found on the two injured person
Yes.
is not possible unless they were crossing the road. If a motorcycle, my lord, comes and hits against, my lord, the two persons going on the left side of the road, these type of injuries are not possible.
Yes. Please come. Agreed, brother. Award passing MVC number 837 and MVC number 1020 of 2011, date 23rd May 2012. The insurance company is before this court. The against the award passed in MVC number 837. MFA number 8646 of 2012 is filed. Against the award passed in MVC 1020 of 2011. MFA 8647 is filed. The case of the claimants before the court was that on 9/1/2011 at about 6:30 p.m. when both the claimants were walking on the left side of the Chikka Uppanahalli, Madurai Road, Dasnapura, Hubli. At that time, the right of the motorcycle came at a high speed and dashed against them from behind, due to which both of them had fallen and sustained grievous injuries. Both were rushed to Markuski Hospital and were treated as inpatient from 9/1/2011 till 13/1/2011. They have spent an amount of rupees 1,50,000 and 1 lakh respectively towards medical expenses. It is a case of the insurance company that the vehicles are not involved in the accident, and the MLC register is not filed before the court. There is no convincing evidence, and the injuries sustained by them also shows that there is a contributory negligence on the part of the claimants. While they were crossing the road, they might have sustained the injuries, but not but not when they were walking on the road. The tribunal, on the issue of the negligence, held that, and the involvement of the vehicle has held that the exhibit P2 charge sheet, which is filed against the driver of the offending vehicle, and the evidence led by the claimants clearly establishes that the accident had occurred due to rash and negligent riding of the rider of the bike. Further, they have also placed on record they examined PW3 and also other medical evidence to substantiate their case. When it comes to the contributory negligence, the court has opined that when it is the case of the insurance company that there is a contributory negligence on the part of the claimants, they ought to have let in some evidence, and no evidence was let in by the insurance company, and accordingly held that the accident they had taken place because of the rash and negligent driving of the driver of the offending vehicle. And as the same is insured by the respondent insurance company, they are liable to pay the compensation. Accordingly, granted an amount of rupees 3,15,960 in MVC number 1020 and an amount of rupees 3,75,000 in MVC number 837 of 2011. Learned counsel appearing for the insurance company submits that as per the evidence of the doctor, Munegowda, that is the claimant in MVC number 837 of 2011, has sustained grade 1 compound fracture, both bones of right leg, upper 1/3, and he was operated under upper 1/3. According to the doctor, there is swelling, tenderness of the right leg, right knee flexion, right ankle dorsal flexion, and the plantar flexion, right is 4. According to the doctor, as far as Manjunath is concerned, he has a fracture of both bones of right forearm, and he was operated on 10/1/2011. Must be sufficient. I ask you to explain. Learned counsel, basing on the submits that if the vehicle hit them from behind and they were walking together, question of sustaining those fractures do not arise. In that case, then we say alternatively we submitted that as they were crossing the road without looking at the vehicle coming from the opposite direction. They had sustained injuries and there is a contributory negligence on their part. He submitted that the accident had taken place on 9/1/2011 and the complaint is given on 11/1/2011. Land Council has pointed out from the complaint that there is some interpolation and correction with regard to the dates. We submitted that the MLC, even as per the hospital reports also, they have not mentioned about the vehicle, the class of vehicle or the number. It is submitted that the vehicle is implicated for the purpose of claiming the compensation. Then council submits that the tribunal, without appreciating the evidence on record, has held the insurance company liable to pay the compensation. Next paragraph. There is no representation on behalf of the respondents. As this is an appeal of 2012. This court is inclined to proceed with the matter and the merits of it. The main contention of the land council for the insurance company is that the involvement of the vehicle is doubtful. Second, with regard to the injuries sustained by them, that clearly indicates that there is a contributory negligence on their part. Immediately after the accident, they were taken to the hospital. As per the hospital records, it show that they sustained injuries in a RTA. Then they were in hospital till 12/1/2011. On 11th, they gave a complaint to the police and mentioning the relative has given the complaint, mentioning the vehicle number. It is nowhere suggested in the entire cross-examination to any of the witnesses that there is a collusion and or that both of them are known to the owner of the vehicle or the driver are known to the claimants and if there is a collusion and they have involved the vehicle. There is no such there is no such suggestion put forth to him. In view of the same, considering the consistent evidence on the injuries, accident, the court is not inclined to appreciate the contention, and the court below had rightly held that the vehicle is involved in the accident. Then comes the question is about the contributory negligence. According to him, considering the injuries, the court has to presume that while they were crossing the road, they have sustained injuries. In this regard, they have not examined anyone. No evidence is letting by the parties. When they're claiming, say that there is contributory negligence, the burden lies on them. Do the same. In these circumstances, and on their submission, the court cannot assume that while they were crossing the road, they have sustained the injuries. In view of this, the court finds no reason to interfere with the award passed by the MACT, and accordingly, both the appeals of the insurance company are dismissed, and the amount in the deposit shall be transmitted to the court.
Please.
Who appears for the respondent?
I pay for the respondent number
Yes.
1, my lord.
Yes. How much amount you claim? Let's see that particular issue and the findings. 1810. Complaint was given. Mention the number of the vehicle. No. 1810-2000.
Use the mic, my lord. Let my learned use the mic, my lord. I cannot hear.
He's not able to hear you. Complaint was when?
Same day, same day.
Is the mic on? Now you are able to hear him?
I'm here, I am here, my lord's voice, but my
No. Your friend's voice, can you hear now?
no, my lord.
I think that is not on. The mic is not on. It's on. So come 8/10/2009 is the accident. Time? Now also you can't?
No, madam.
Or else can you use this? He's not able to hear you, it seems. That might. And the complaint is given when?
Same day, sir. Same day.
Time. In that they mentioned the car number. What is the vehicle involved?
Vehicle involved is lorry. He was a brilliant rider in a motorcycle.
Now let us see how the court below had dealt with that issue. Para number?
Nine.
Yes.
It is pertinent to note that here, that it is relevant to vehicle not at all cause an accident, there is no action. And stated by him in the evidence, whether it is registered to vehicle one medical record, the accident occurred at the vehicle. And they were proceeding the hospital,
Why in the medical records you said so? That auto is involved in that.
Sometimes considered as a yes.
At the earliest point of time, use the record.
Certificate. Yes, point of time, I mentioned and I. It is PC.
Tuned above left side to info. Where will you get that? History of road traffic accident. That's where you say that about the auto.
There is no mention of auto in the own certificate. Here, prepared by the hospital authority, subsequent to this, PC, they mentioned auto. It has been taken into consideration and that is the reason why the.
So why that has crept in that?
I don't know, because this.
No, why will they write something on their own? No, in the case sheet, no, in this they have mentioned the time. Time is 11:30 p.m. No. Time is 11:30 p.m.
Yes.
When is your report to the police?
Same. With the.
Anyways, okay.
FIR is everyone with complaint.
It's a key one. No, that is next day you have given the complaint, not on the same day.
10:45 PM. Within 45 minutes, you went to the hospital.
No, date 10/18/10/2008. Time 22:45. Occurrence of offense. Information received on 19/10 at 12:30. Next day afternoon.
In the hospital, I was treated as an inpatient. It is written by the doctor who was in the.
Lorry number is also mentioned. So now according to you, 18/10/2019 time was 20, it is at midnight. It's 10:45. Next day morning, 19:10, time was 12:30. Afternoon, within 12 hours, it is given.
45 minutes, I reached the hospital and given the right then the lorry itself. In fact, lorry driver has been pleaded guilty because of the
You are traveling on a,
motorcycle.
your vehicle number is?
My vehicle number is KA05 HE 1605. The lorry number is RJ 02 BA 22. The phase 2 of the.
And where is that case sheet which refers to auto? Exhibit
With
with reference to the above summary the motor. Send my address and exhibit.
Taken by the doctor was the operation theatre.
Details in MLC register. Alleges to have RTA when he was back seated, hit by auto rickshaw at level 35 PM.
That's not.
It supposes that the entries are wrong at BTM signal. What do you say? Now in the case sheet, in the case sheet, it says that a case of RTA, when he was sitting, when he was back seated, hit by auto rickshaw at 11:35 PM.
My lord, I will be present at 2:30, my lord, before physically I will be present before the court at 2:30 and I will argue. If my learned friend has finished his arguments, I will argue.
Password. Password. Serial number 10. No, to post it for judgment, not reserved. We'll hear you. That's why it is adjourned. It will come up for judgment, not for pronouncement. We'll hear that day.
Number 20, Mahesh.
Serial number 20.
Yes, Mr. Mahesh. Mr. Mahesh,
Oh, Mahesh, sir.
he will become pass out. Yes, Mr. Guru Prasad, next matter.
Lords, I appear for respond number 2, insurance company in this matter.
Case of injuries. When amount is 10 lakhs.
How much is granted?
2 lakhs 35,000.
2 lakh. Liability?
Insurance company has been external.
What do you say on that? Let's see from do the lower court record.
What is the?
Para?
Different couple. Different couple.
Let's see. 14 or 44? Hmm.
You have the evidence of second response. It is the evidence of other relevance. We need the administrative officer would have to created and manipulated as if we call out or issued on high side. So.
Who is this, their agent? Then how are you responsible? See, Srini, the administrative officer, the first respondent has created and manipulated as if the cover note was issued as Ali's car bearing number was involved in the accident on 11 and forwarded the check as well as a cover note on 16/7/2010. What is the date of accident? 11/7/2000?
Or not produced before mention the engine number and tracking. But the temporary registration number varies. The chassis number and the engine number is correctly mentioned in the cover. According to the RW1, the officer of the insurance company says they have issued particular views of cover note to this customer's calling dealer. Then they admit that they have issued even leaves in advance to the dealer. If the dealer has manipulated or issued arts cover note, it is the responsibility.
No, here you understand one point. No, accident had taken place on 11/7. According to them, the check as well as a cover note were forwarded on 16/7. 16/7. End of the same para. End of 44. That's a issue.
Yes. When they invented the problem of issuing the cover notes in advance.
I'm not on that. Court is not asking you about the liability of that or their inter se, whatever the problem. No, accident had taken place on 11/7/2010. Your cover note is supposed to be there on that day. Now, your check as well as a cover note are on 16/7/2010. Mentioning some retrospect. That's why we will see at that that is marked as exhibit.
It is not that the check has been dishonored. So that was premium.
No, not that. If you issue the check after the accident date, then that presupposes that there is no cover note. No. You should. Why would he give a cover note without you issuing a check?
I have an issue.
When did you issue the check? That is some.
Check is dated for 5/7.
That's why we'll look at it. Refers to the claim lodged by you in respect of vehicle number so and so. Policy commences from 26/7. So I'm looking at the document. What is this marked as? I don't know. Nothing is shown here. It says, on scrutiny of the documents submitted by you that the policy commences from 26/7/2010 to 25/7/2011. Whereas the accident is reported on so and so. Hence your claim is not admissible. Then it says you have received a summons and copy. Your temporary vehicle registration is from 16/7/2010 to 14/8/2010. Then there is a question of issuing the even the cover note before the temporary registration.
New item. This should not on I7. I7. Because there is what we have discussed.
No, it doesn't require temporary registration also for giving a insurance policy. Then you have to mention something on the, not the temporary registration number is not required.
One more is the issue of.
Where is the cover note?
Everything.
Amen. This is the R6. Cover note is the R6.
Next one is.
What is this? Copy is not meant to be used for assumption of risk in any form.
What needs to be. The agent or somebody, some of the people will be. What it is. The pattern topic is. One used to be given to the. Following this policy will be.
Well, what is the then? What is the significance of this? Whether
We have to cover what rated insurance.
so it means by that date, which the day on the date on which this cover note is issued, the policy comes into existence. No, why this mention of copy not meant to be used for assumption of risk in any form?
Because this is what this can use only this is only for that. Before the expiry of that event, the policy is actually issued. This kind like an agreement, insurance agreement.
Subject to realization of the check or what? No, where do you get any of the details on this?
Normally they have a interest on.
Hmm.
But here it is not followed.
No, chases number and all, where do you get?
They update the check.
No, on this you should continue.
Engine number CEV.
Hmm.
Number 05236. That's the number EMB EH. 1512.
5/7/2010 Can the cover note be like this? Containing nothing.
It is a breakup format. It is normally a prepared. That has been produced by the insurance company. So now, not be in the breakup format. The original is supposed to be all of it. One copy is left to the insurance. Because it is mandated that at the time of this section, the insurance has to be.
Yes, Mr. Counsel, appearing for the insurance company. What do you say?
Lodge. The vehicle involved in the accident has two temporary registration numbers. And cover note bearing number 2276 has been manipulated and created.
By
And it
whom?
is created by the first respondent, my lords, by the owner. Kindly see paragraph 53 of the judgment. This comprehensively deals
No.
with the manipulation.
The judgment, no, before the court below, your plea is that is done by one of your officers, not the owner of the vehicle.
Not by the officers. It is their contention of the company that the cover note has been manipulated by the first respondent so as to cover the accident.
Let us see, please come to the order. Then we will read from the order.
Kindly see para 53 of the judgment. Shall I read, my lords?
1 minute, 1 minute. So first respondent is the owner of the vehicle.
Yes, my lord.
Mm-mm. Which para 50?
53. my lord.
Please read.
In the case on hand, the defense of the second respondent plays an important role, as the first respondent has created and manipulated
No,
the
you're
cover
reading 50?
3,
Oh.
53,
Hmm.
page 23 of the judgment. It is the case on hand. The defense of the second respondent plays an important role, as the first respondent has created and manipulated the cover note number 2276 as if the same was issued on 5/7/2010. The contents of the documents referred to and relied upon by the second respondent makes it very clear that the car bearing registration number KA01 TRMB 744 was involved in the accident on 11/7/2010. Hence, the first respondent manipulated and referred documents as if the said car was insured by a cover note number 2276 dated 5/7/2010. It has also been proved in respect of same engine number so and so and chassis number so and so. The first respondent has got two temporary registration numbers. It is undisputed. Wide letter dated 16/7/2010, the first respondent has issued cover note number 2277 in respect of car bearing number registration KA01 TRMB 1107. That is in respect of the second temporary registration number, my lords.
No, you say that the first respondent has issued the cover note. Who is the first respondent? Is the owner of the vehicle. Where is the question of you? First respondent issuing the cover note? That's what there is something wrong with referring to the respondent.
The showroom, my lords, the first respondent is the showroom. Therefore, they issue the cover note.
Hmm. No, you said first respondent is the owner of the vehicle.
Correct. They are the owner of the vehicle as well. They are the showroom. The car
Showroom
showroom.
people have issued. Hmm.
Then, my lords, it is also undisputed in view of the misuse of the cover notes. The second respondent has taken back all the remaining cover notes from the first respondent.
So you have issued the cover notes to first respondent. According to you, first respondent has misused the cover notes and did something.
Correct. It is backdated.
So
It
you
is backdated.
don't dispute the fact that the cover notes were issued to first respondent. First respondent did something. For that, why should he pay?
The first respondent has issued the cover note to the in respect of the vehicle, offending vehicle. It is not the insurance company which has issued the cover note.
You have given to him the cover notes for use.
That is subsequently called back as well. All the cover notes are called
If
back.
subsequently you call back or what happens between your agent and you, that is not the botheration of the owner of the claimant. You have to settle with them. For the mistake of your agent, why should they be, they should suffer?
The cover note never formalized into an insurance policy. It was
30 days it would be there.
Plus,
For 30 days it would be in operation till you issue it will follow, the policy will follow.
my lords, I would need a moment. If I may consult my senior in this regard and get back to this honorable court.
Yes.
Since this is an old matter.
Anyway, you have one passover, another passover. No, that too in I think some stamps like this have taken. In all that the courts have taken the view, take care of your that whoever is concerned agent, and they are not concerned with it.
May I make one submission, Malad?
Oh? Submitted that some personal inconvenience to the council for the appellant post after 2 weeks. You're here till now?
Yeah.
Well, serial number 17 and 20. 20, I already informed the home Mahesh also. Even 17 also. Malad, tomorrow or day after tomorrow.
Every day, these kind of accommodations will not do, Mr. Shah. Please.
My lord, serial number 25, my lord.
Court officer. Court officer.
Yes.
Serial number 29 adjourn ಆಗಿದೆ sir.
Serial number 29 ಇದೆ sir. ಇದೆ sir, ಅಜ್ಜನ್ ಆಗಿಲ್ಲ.
ಪಾಸ್ಡ್ ಅವರ್ ತಗೊಂತಾರ. ಮಧ್ಯಾಹ್ನ ಪಾಸ್ಡ್ ಅವರ್ ತಗೊಂತಾರ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ.
ಫಸ್ಟ್ ಪಾಸ್ ಓವರ್ ತಗೋತಾರೆ ಸರ್. ಪಾಸ್ ಓವರ್
ಮೇಡಮ್ ಎಷ್ಟಿದೆ ಪಾಸ್ ಅವರ್?
1, 2, 3, 4 ಪಾಸ್ ಓವರ್ ಇದೆ ಸರ್. 4 ಪಾಸ್ ಓವರ್.
ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್. ಓಕೆ.
24 ಇಂದ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಪಾಸ್ ಓವರ್ ಆದ್ಮೇಲೆ.
ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್.
ಮೇಡಮ್.
ಎಸ್
28 ಇದೆ.
28 ಇದೆ ಸರ್. ಇದೆ ಮ್ಯಾಮ್.
ಸರಿ.
Court officer? Hello, court officer?
Yes, madam, ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಏನಾಗಿದೆ ಮೇಡಮ್ ಅದು?
Serial number 16, list for dismissal tomorrow. ನಾಳೆ ಬರುತ್ತೆ ಮೇಡಮ್. Under the gap.
ಓಕೆ ಮೇಡಮ್. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Hello? Madam?
ಹೇಳಿ ಸರ್.
Hello? ವಿಡಿಯೋ ಬರ್ತಾ ಇಲ್ಲ, ಇನ್ನು ವಿಡಿಯೋ ಬರ್ತಾ ಇಲ್ಲ.
ಅದು ಸ್ಟಾರ್ಟ್ ಆಗ್ಬೇಕಾದ್ರೆ ಆನ್ ಆಗುತ್ತೆ ಮ್ಯಾಮ್.
ಹಾ, ಆಯ್ತು.
No, all the passwords. The other passwords. For enhancement. How much was the claimed amount? How much you claimed? How much you have claimed the compensation? Awarded is 84,000. On what ground the insurance company is exonerated? Because I don't remember how many cases I gave. Yes. The number level.
Based on the report of the private investigation by the respondent insurance authority, it is produced before the court will. That on that basis, the court will come to the view that the settlement submitted to it are one of the judgment of the court to the internal payment of 6 and 7.
Is it? This.
Now let me see whether the petition was traveling in the background or it was proceeding by law. It is not claim that he was proceeding along with one on the left side of the road. The doctor has given PW2 also regret this. Also find insurance claim that for the private investigation conducted by the people who are sitting on this room, so the dialogue and this time.
No, I remember. You say that even that day you are submitting that the investigator was not examined. Now, you yourself admit that as per the investigator's report, what you have stated before him and your signature on exhibit R1, number 1. Next is, even as per the medical report also, that you have fell down from the moving tractor. These are the two things which are against you. If you don't dispute that, you don't have a case.
Regarding judgment, objection statement
Admitting facts need not be proved.
No, Lord. Without pleading, it is about the evidence or argument not because in their objection statement, my Lord.
Forget about them. Have you admitted that or not? Your signature is on exhibit R1. Take the evidence of PW1.
Most importantly,
Yes, submitted the transaction copy.
but in this statement, R1A and R1 kind of an issue. But the witness, that is PW1, the claimant, it doesn't know to read or break the transaction. Except my Lord, the respondent does not put any further cross examination after the action. This is the admitted fact.
No, you have filed the cross-examination and I mean the evidence. What is this translation? I'm not able to understand. I'm always going to fully work. I do not know the so and so. I do not know that I was sitting on the said stone lorry in the tractor trailer and others were sitting on the mudbed of the tractor. I do not know the said road slope. I do not know. I was injured. How can you say I do not know? What you, if you are not sitting on the stone, you should say that I am not, I was walking on the road, but not on the, I was not sitting on the stone load. What is this? I do not know. I do not know the. How can you say? If you there that you are sitting on the road on the load, you would have said I am not. I'm not. Hold down from the tractor. Who else was examined? PW2 is who? Take out the medical evidence.
Insurance will be asked to, but they are also personally insurance covered by the insurance. Walking on the side of the road, this person back.
When is the date of accident?
Date of accident,
12/2. You went to the hospital on? It was on 13/2. As per the wound certificate. Date of admission is on 13/2. Date of discharge 16/3. Fall from a mini tractor on 12/4 at around 11 a.m. At 2:30 you went to the hospital. Yes, P8. Karnataka, where is
medical department would say.
Karnataka Medical Department wound certificate? What is this? And what is this? Exhibit P8. Rajiv Gandhi Institute of Chest Disease.
There is Bangalore, the doctor is stated Usually, expert P60 Chikmagalur doctor. Thereafter, due to the head injury, the kind of insurance company not examine the author of the argument.
No, let's forget about that author. Let's look at how you have discharged your burden. When was the complaint registered?
Registered as on the
Date, please give the date. Well, two. What did you mention in that? That is exhibit. It's 14:30. That is 2:30. That complaint. What did you say? Details of known suspect, unknown accused, particulars, tractor driver. Column number 12, read. Oh, read and read. Column number 12. Can read the complaint next. Exhibit. Read the complaint.
ಈ ಮೂಲಕ ನೀಡುವ ದೂರು ಏನೆಂದರೆ ದಿನಾಂಕ 12/10 ಸಂಬಂಧಿಕರಾದ ಕೇಂದ್ರಗಳು ಹೋಗ್ತಿದ್ದಾರೆ. Tell my lord at morning on the Alsapura Dodama temple road. Then myself and my relative Kengegoda is going on. Alsapura ಕಡೆಯಿಂದ ಒಂದು ಟ್ರ್ಯಾಕ್ಟರ್ ತುಂಬಾ ವೇಗವಾಗಿ ಬಂದು ನನ್ನ ಪಕ್ಕದಲ್ಲಿದ್ದ ಕೆಂಗೇಗೌಡರಿಗೆ ಡಿಕ್ಕಿ ಹೊಡೆಯಿತು. That the tractor coming from the Alsapura side with speed and this speed and dashed the Kengegoda. ತಲೆಗೆ ಕೈ ಕಾಲಿಗೆ ಪೆಟ್ಟರು. Due to this accident, my lord, the Kengegoda, that is the petitioner, claimant as injured for the head, chest, and to the leg. ಕೆಂಗೇಗೌಡರಿಗೆ ತುಂಬಾ ಪೆಟ್ಟು ಆಗಿರೋದ್ರಿಂದ 108 ವಾಹನಕ್ಕೆ ಫೋನ್ ಮಾಡಿ ಚಿಕ್ಕಮಗಳೂರು ಆಸ್ಪತ್ರೆಗೆ ಆಂಬುಲೆನ್ಸ್ ಆಂಬುಲೆನ್ಸ್ ಚಿಕ್ಕಮಗಳೂರು ಹಾಸ್ಪಿಟಲ್. ಈ ಕೆಂಗೇಗೌಡರು ಡಿಕ್ಕಿ ಹೊಡೆದ ಟ್ರ್ಯಾಕ್ಟರ್ ನಂಬರ್ ನೋಡುವಾಗಿ KA13TA1630. The tractor number is KA13TA1630. ಟ್ರ್ಯಾಕ್ಟರ್ ಚಾಲಕ ಅಪಘಾತದಲ್ಲಿ ಟ್ರ್ಯಾಕ್ಟರ್ ನಿಂತು ಡ್ರೈವರ್ ಆಫ್ ದ ಟ್ರ್ಯಾಕ್ಟರ್ ಇವರ ಬಗ್ಗೆ ನಮಗೆ ಯಾವುದೇ ಮಾಹಿತಿ ಇರಲಿಲ್ಲ. KA13TA ಚಾಲಕ ಅತಿ ವೇಗದಿಂದ ಅಜಾಗರೂಕತೆಯಿಂದ ಚಾಲನೆ ಮಾಡಿದ್ದಾರೆ.
Mr. Mahesh, what do you say? Now, in this, the accident had taken place on 12/2/2010.
Yes.
At what time?
11 AM.
Huh?
11 AM morning.
11 AM. And a complaint was given at 2:30,
Yes.
where the name of the tractor and the details were mentioned.
Yes.
In the initial MLC, before that other hospital, it is only mentioned as RTA. Then he was admitted in another hospital on 13th. In that, it is mentioned that fall from a mini lorry, a mini tractor.
Exhibit P8 is the own certificate which is produced by them.
Huh?
Produced by them.
Yes.
There it says fall from the tractor. Then I invite your worship attention to my lord, the evidence of my lord, the injured PW1. The translation now it has been given.
Now, please point out the relevant one because just now he read that.
Yes.
Point out at the relevant portion.
Exhibit R1, my lord. I'll read the my lord, cross-examination of PW1, the translation. Cross-examination by KVM for respondent number 3. Para 3. Lordship got it, my lord? Chandra is my relative. It is true that one Ravi is the brother of Chandra. It is true that the father name of him Kingi Gowda. It is true that the tractor owned by Ravi. It is true that in my village there is a Nailegele hill. It is true that the villagers bring the stone from said hill. I was doing my signature and now I am seeing my signature and photo. Said statement document got marked as exhibit R1 and signature marked as exhibit R1A. Now we are kindly look into my lord this exhibit R1. Translation of copy of exhibit R1 to the manager, Bajaj Alliance Insurance Company Limited, Mysore, from Kenge Gowda, 55, son of Ninge Gowda, Kalsindapur Post, Gurupara Street, Chikkamangaluru Taluk, Chikkamangaluru District. Sir, I am residing in the above address. I am working as a coolie for my livelihood. On 12/2/2010, I went to loading stone in the tractor at Nailegil Hill. Along with me, 4 police workers were sit on the tractor. Said road slope, the engine and the trailer both fell down, and who sit on the engine, no injury caused, but as I was sitting in the trailer, the injured left side, my head, injured left side of my head, ear, left hand, left leg, and side of my body, and my bone broken. Due to the accident, I cannot do the coolie work. My family depend on the coolie work, and it earning, though I am not. But here it has been exhibit R1, my lord, has been admitted by him, which is with his photo. Now exhibit R1 may kindly be looked into, my lord.
Yes.
Where, my lord, it is stated, he has admitted, my lord, that exhibit R1. Where it is, my lord, he was sitting on the track.
Yes.
In the claim petition, his case is, my lord, because in the tractor he may not get compensation, they come on the road. Exhibit P8 own certificate, my lord, produced by them, not disputed by them, says, my lord, fall from the tractor. So under these circumstances, my lord, the tribunal has rightly, you have to kindly look into, my lord, exhibit R1, the photo is also there, and the signature is also admitted in the cross-examination.
Yes.
So when exhibit R1 is admitted, which is supported by own certificate exhibit P8, that they were traveling in the tractor. Realizing that that risk is not covered, then they come on the road. Whether this type of can be encouraged by the Quotes. The complaint, my lord, is on 12/2/2000 at 14:30 hours. This is a clear case of murder concoction.
So you are saying that he cannot sign in Kannada?
That's why in reading and writing, that's why you re-examining. Re-examine. After this,
No, I'm asking, can he sign or not?
He has admitted his signature.
If you look at the claim petition, he has signed on that. Claim petition was signed by him.
By him only.
No, everything, not whatever may be. You have to answer to the query. Just
what is signature?
no, just before this, you said that he cannot write, he cannot sign. This is a signature.
Signature they know, he knows. Not regarding the writing and the reading. Why the concept for competition requirement could be the re-examination. But when re-examination, no process and very incidents.
Where did you say so in the examination that he cannot speak? I mean, he cannot.
After process on re-examination.
His signature on deposition as well as on exhibit R1 may kindly be compared.
That's what I just now I saw. Signatures are as it is on the claim petition and on exhibit R1. If you have, please look at it.
And deposition also. Examination chief by way of affidavit. The signature is also.
They have not examined the author of them. That's the case. The Honorable Court below believing the R1, what is the matter? When they have not examined the witness, author of the R1, the court below, you get to the based on the believe the word exhibit R1.
Why are you saying that I saw the signature, it is mine, it is marked as so and so? Why did you not dispute it when it is confronted to you? For everything, that can't be an answer. The villagers bring the stones from the said hill. I am doing my signature and now I am seeing my sign and photo. Said statement document marked as exhibit R1 and signature marked as exhibit R1A. You do not deny the signature. Do not deny anything on exhibit R1. Court taken it as an admission.
Absolutely, the court has not
That is a secondary aspect. That's a secondary aspect. First aspect is, have you denied it? Then some document, you don't even dispute it, then where is the question of proving it?
The person does not know the contents of that
You should have said so.
document.
No, you should have said so that the signature is mine. I don't know the contents. What to do? But he is represented by an advocate. That ground can't be considered. This is an appeal filed by the claimant, agreed with the award passing. MVC number 6/2012, dated 26 July 2012, whereby the court below had granted compensation of an amount of 84,000. However, absolve the insurance company from the liability. Liability and held that the owner alone is liable to pay the compensation. The case to the claimant is that on 22/2010 at about 11 a.m., the claimant was proceeding by walk along with Ram Chandra on the left side of the road towards Vardhama Temple. At that time, the first respondent, being the driver of the tractor, driven the same rash and negligent manner and dashed against the petitioner. Due to the accident, he fell down and sustained injuries to head and other parts of the body. He took treatment at MD Hospital, Chikmagalur, Enhanced Bangalore, and started plans to Bangalore for more than 21 days. The liability, the court below has held that, has observed that the case of the claimant was that he was walking along with one Chandra Gowda on the left side of the road and tractor dashed to him. And according to the insurance company, as for the private investigation conducted by them, the petition on the stone load in the trailer attached to the tractor. The other workers were sitting on the engine. The accident occurred while the tractor was proceeding in a down gradient road, and in order to fasten the liability on the insurance company, the petitioner has falsely alleged that they were proceeding by walking on the road. In support of their case, the insurance company has examined its legal executive as RW1 and marked Exhibit R2 to R4. RW1 is authorized person of the company. The court observed that PW1 admits the investigation done by the previous respondent. The cross-examination. The claimant admits Exhibit R1 and his signature thereon, stating that he was traveling in the tractor and fell down and sustained injuries. Exhibit R1 clearly speaks that the petitioner was traveling in the trailer by sitting on the stone road. As the accident occurred, and the accident occurred in the down gradient road, he suffered injuries. The court below observed that the evidence is corroborated by the history noted in the wound certificate. That is Exhibit P8, which indicates fall from the moving tractor. The complainant is known to the injured and is a relative of the petitioner. The court below, considering the evidence of the admission of the petitioner on Exhibit R1 and the investigation report Exhibit R4, that the petitioner was traveling with the tractor in question by sitting on the stone road has held that insurance company is not liable to pay the compensation, but it is owner who alone is liable to pay the compensation. Agreed hereby and granted the compensation of an amount of 24,000. The agreed hereby the payment is before this court, and counsel appearing for the payment submits that the payment was a coolie and he is not conversant with the language as such. He didn't know the contents of the report. He submitted that the respondents have not examined the insurance company has not examined the investigator who has who is the author of Exhibit R1. It is submitted that without examining the author of Exhibit R1 and without any pleadings to that effect, the court below ought not have given such a finding. It is submitted that that they have given a complaint on the same day, wherein they mentioned about the involvement of the vehicle, they mentioned about the manner in which the accident had taken place. Land council submits to the court below, without appreciation of the evidence on record, had dismissed the petition, had absolved the insurance company from the liability. Land counsel appearing for the insurance company submits that the court below submits that exhibit R1 contains the signature of the claimant. He submits that even for a naked eye, the signature on the claim petition and the signature on exhibit R1 is one and the same. He submits that when he himself has admitted about the signature.
Document, my lord, is his wife and the neighbor. Witness to exhibit R1, my lord, his wife and neighbor Indira.
And the witnesses to the said document are his wife and neighbor, and also the neighbor. And when he has admitted the signature, and nothing has been put forth to say anything disputing the said document, mere non-examination of the author of the exhibit R1 cannot be a ground. So, not to consider exhibit R1. It is submitted that exhibit P, that is P8 own certificate. Exhibit P8 own certificate. It is clearly mentioned that he fell from a tractor, fall from a tractor. All these things support the case of the insurance company, and the court below had rightly dismissed the claim petition. Has rightly exonerated the insurance company from the liability. Having heard the counsels on either side, there was entire material on record. It's a case of the claimant that while he was walking on the road, a tractor dashed to him and sustained injuries. Exhibit P8 is a document filed by the claimant. That document, as per the said document, he fell from a moving tractor. Why such an entry is made to the medical records which are filed by him and filed by him? There is no experience forthcoming, and they have not taken any steps to examine the concern. That apart, exhibit R1, the payment did not dispute anything with regard to exhibit R1. However, learned counsel says he doesn't know he doesn't understand, he didn't understand the contents of exhibit R1. For that, there was this court having gone through the evidence in chief and the cross-examination of PW1. Absolutely, there is no denial of exhibit R1. In of the same, the contention of the non-counsel for the petitioner that unless the author of the exhibit R1 is examined by the insurance company, it cannot be believed as the court below rightly considering the exhibit P8, the exhibit R1, and the evidence of PW1 had rightly come to the conclusion and exonerated the insurance company. Court finds no reason to interfere. Accordingly,
Exemplary court has to be bloody for such cases.
we'll think about it in your case sometime.
I am appearing only in those cases.
Okay.
Ready?
Well, I am for appellant, my lord. My lord, claimant's appeal by the rider and filan rider. Serial number 17, my lord.
Yes, there are two appeals.
Yes, one is by the rider and another is the filan rider.
No, like, what was, the insurance company was held liable?
No, my lord, the claim petition has been dismissed. My lord,
Let's see, what are the two claim petitions? Let us see.
my lord, Darshan 8373. It is
No.
arised out of MEC 1459 of 2009.
1459 of 2009.
2009.
What is the corresponding, he's a rider or a pillion rider?
He is a rider. He's a rider.
What is the corresponding appeal?
8373 bar 2012.
8373 of 12.
12.
And then
And
next is 1460.
Of 2009, it is filed by the Pilan rider 8374 of 2012.
8374. Straight away come to the liability aspect.
My lord, issue number 1, my lord, what happened is, my lord, immediately after the accident, they lost the consciousness. LOC, my lord, the tribunal misinterpreted it as a no loss of consciousness. There is a specific
Let us read and understand.
My lord, the para number 7, issue number 1. Madam, merely because after the accident, one unknown person,
Mr. Shastri, let the court also understand. I don't know what are the facts unless I read it. Please read.
I again say that as per the petition, they suffered injuries. May I read?
Please read.
And trailer, which caused by the respondent number 1, one came and dashed to their motorcycle, whereas admitting the issuance of the policy in respect of the said tractor and trailer, the respondent number 1 categorically denied that the said vehicle was involved in the impugned accident. In view of the specific defense, I have to find out who will stand to the allegations. No doubt by adducing their respective oral evidence, which is a replica of the petition averments, the PW1 and 2 produced the police documents, FIR, complaint, spot measure, motor vehicle report, wound certificate and charge sheet at exhibit P1 to P6 and the P13. But it is rightly pointed out by the respondent number 1. The wound certificate issued by the RL Jalappa Hospital marked as exhibit P5. Right? This is the first time the first admission to the RL Jalappa Hospital. R5 and P13 show that these petitioners were taken to the said hospital by one M. Rajshekar. And as per the history furnished, that these victims suffered injuries on account of skid and fall from the bike. It is also extracted. Alleged history of RTA due to skid from bike and about 11:33 a.m. at 7/10/2008 near Tumkur. Tamaka. Tumkur.
So, as per exhibit P2021, it says it's a skid from the bike.
Skid and fall from the bike. Well, since there is a wording used, extracted, LOC. Right? There is a loss of consciousness, but the tribunal interpreted it as a no loss of consciousness. My lord, that caused these mistake. My lord, in the evidence examination in chief itself, I narrated.
When was the complaint given?
Immediately on that day, my lord.
Same day.
Same day.
By whom?
One.
Who is he?
I have no police
Then
documents.
who lost conscience?
My lord, both lost consciousness. My lord,
What is the time of complaint? Time of complaint.
No.
1:30
11:30 AM is the accident.
1:45 PM.
PM.
11:30 AM
11:30
is the accident.
accident.
One of the pillion rider gives a complaint at 1:45. Rider gives a complaint. He says he is unconscious. What did they say in that complaint? And medical records, what is the time? Oh, the claimant. Hmm. No, if they lost conscience, how can they give complaint within 2 hours?
No, he's a rider. Rider lost the consciousness. Pillion rider, my lord, what happened is, my lord, in the examination chief.
Give the complaint.
That's why police, I have no police document, my lord, is there.
Who gave the complaint? Complaint is given by the rider.
My lord, 1 minute, my lord. In examination chief, I narrated all the facts, what happened. My lord, since he lost the conscience, when Rajshekhar admitted this boy to the hospital. My lord, after that, my lord, after regained the consciousness, my lord, the police came to the hospital and recorded his statement. And my lord, see, after knowing that, if we, after coming to the knowledge of the claimant that there is a mistaken entry in the records, my lord, he write a letter to the hospital authority to rectify the same.
Immediately, within no time, the complaint is also given.
Yes.
That's also at an earliest point of time. Why we shouldn't consider that? I am very.
Well, more.
IMD report dated. Well, but as per that, no damage to the tractor.
Motor. It is they are riding the motorcycle. How these tractor trailer cause the damages. My lord, in the examination chief, my lord, may kindly see my examination chief. My lord, he is a MBBS student.
You can understand if they have given the complaint at a later point of time, and the contents of the medical records are different from police record. But immediately within 2 hours, at the earliest point of time, complaint was given. In the complaint, they have narrated about the tractor and all. So question of implicating the vehicle And sometimes, these, in all we have been seeing, they write so many things in this.
Medical records. My lord, if my,
Huh? Please wait, Mr. Shastri. Yes. Hmm. Owner of the vehicle contested. Hmm. Hmm. There are any eyewitnesses to this incident?
my lord, I have produced the indemnity bond executed by the tractor owner of the tractor before the police authorities. That is also came to be marked, my lord. And exhibit 30, my lord, exhibit 30 and 31 and 32 is the indemnity bond executed by the owner of tractor trailer. My lord,
It is rejected by them.
my lord,
Yes,
my lord, kindly see my examination chief. In the examination chief, my lord, in para 2, my lord, I have specifically pleaded in RL Jalapa Hospital by the person I was unconscious. I was admitted by a person when I was unconscious. Further, the history of accident. History, my lord.
Exhibit complaint. P2.
My lord, the history given by an unknown
Fine,
person.
please wait for a minute. I'll ask you. Will you give you an opportunity? Please wait. No. Where is this? One minute. P1 is the affair. Date 7/10/2008. Date says who is the complainant? Shyam is the complainant. That is the rider of the vehicle.
No, he's the pillion rider. Sham is the pillion rider. Darshan Deep is the rider, my lord. Sorry. Darshan Deep is sorry. Darshan. Sorry. Darshan Deep is a pillion rider.
You said this repeatedly. Even if the court is telling you that he is the rider who is the complainant, still you are saying.
My lord, that mistake. Why I try to take an adjournment because I have no document. My counterpart has not furnished with any document. That is my problem. And I am only by relying on these documents, my lord, arguing is it may lose my weightage also. My lord, kindly see my examination chief affidavit.
So this person is Darshan Deep. Immediately I was shifted to Jalapa Hospital. Where the person there, as I was unconscious, the history of accident was entered wrongly to the doctor at the time of admission, but immediately after some time, Police came to the hospital, recorded our statement correctly before the doctor, and case was registered. Later on, we came to know the mistake of the case, so in fact. They know what this person says. No, this cross examination is in Kannada, I think. Respondent number 2 in the said letter. No, Shyam was the person who is the driver. He was conscious. Only he has suffered simple injuries. He has given the information. Hmm? Is there any connection between the vehicle, the owner of the vehicle, and these people? Then why do you think that only why they should implicate that particular vehicle when there was no accident? Hmm. Only one important aspect in this case is the complaint. Complaint which is given within 2 hours, where they mention about the number of. No, why we say, because whenever we look at the medical records, we say that it's at the earliest point of time. And the complaint, they get some time to, to implicate the vehicle and all. But immediately, they've given the complaint and mentioned it. So just because basing on the medical records, why should we disbelieve this police record?
Police records also. Identity is honorable. And the same way it was.
No, it's a small vehicle, two-wheeler. Two-wheeler, that's a small vehicle. You said from the back or front? But injuries to, I think the tanker, the petrol tank is damaged. And what are the other damage to the vehicle? Rear? What is the third one? Crushed? Oh. Possible. All these damages are possible if they are hit by the vehicle from backside.
The PLR should have been died.
No, even in this case also, pillion rider was unconscious, according to them. Not the injuries were not to the rider of the vehicle. Pillion rider's name is? His father is a doctor. You said that if they're simple injuries, why was he operated? If they are simple injuries, why was he operated?
He was operated in his
No, but that we cannot do. When his father is a doctor, we can't disbelieve that. And they will go and have the operation there only. You are only believing on the wound certificate, the entries in that, and second is the MBR report. Okay, that will carry whatever the entry first time is. So at what time he came to the hospital? Time. We'll see. No, we'll see from the case sheet. 2:30 p.m. 2:30 p.m. is the wound certificate. And the police report is much prior to that. So why should we believe this but not that? Oh, after the report. So a person who has given a complaint prior to the entries in this wound certificate, prior to his medical examination, why would he say something contrary to that? I'm looking at P5. Yes. Time of examination is 2:30. No, but it says first commenced at 2:30 p.m. The same. I'm looking at it and you want to look at exhibit P. Here they don't mention about the time. Jalapa Hospital. They don't mention about the time in this. Will remind the market to consider about the compensation. Yes, Mr. Shastri. To both the parties. Filed by the claimants. The two appeals are filed by the claimants. Agreed with the dismissal of MBC number, dismissal of MBC number 1459 of 2009 and 1460 of 2009, dated 7th January 2012. The insured are rider and the pillion rider. The pillion rider,
Darshandi.
the rider has filed MBC 1459 of 2009 and the pillion rider MBC 1460 of 2009. Rider is 1459. Oh, 1460 is the rider. MBC rider has filed MBC 1460 and the pillion rider filed MBC 1459. What are the corresponding appeals? Pillion rider?
8374, my lord.
Please.
Sorry. 8373.
The second number is
number.
8373 by pillion.
the pillion rider has filed 8373 of 2012, and the rider has filed MFA 8274 of 2012. 8374 of 12. The claim petition is filed stating that on 17/2008 at 11:30 p.m., while both the claimant were proceeding on the motorcycle, the claimant in MBC number 1460, that is the rider of the motorcycle, along with the pillion rider, when they were proceeding near Baswanta Ghat, Vidyajyoti Cross on NH4 Kolar Town, a tractor and trailer came behind the motorcycle in a high speed in a rash and negligent manner, dashed with their vehicle. As a result, the rider as well as the pillion rider fell down and suffered considerable injuries. They took treatment at RL Jalapa Hospital, and after treatment at BGS Hospital as well as Subhash Medical Center. It is a case that they are the students of MBBS, and because of the injuries, they were unable to attend the classes regularly. And claim the compensation for the injuries sustained by them. The court below, first on the issue of liability and the involvement of the vehicle, the court had considered the exhibit P. The court has considered Exhibit P5 and Exhibit P13 that the the claimants were taken to the hospital by one Rajshekhar, and as per the history furnished, the victim suffered injuries on account of skid and fall from the bike. The court has observed that not only these two documents, they are further corroborated by case sheets of RL Chalapa Hospital, produced as Exhibit P20 and 21. Exhibit P20 is in respect of the pillion rider, and P21 is in respect of the rider. The court, considering these documents, had held that there is no vehicle involved in the accident, and only for the purpose of claiming the compensation, the vehicle has been implicated, and dismissed the claim petition. And counsel appearing for the claimant submits that it is submitted that immediately after the accident, the pillion rider was unconscious, and they were taken to the hospital. They have sustained a lot of injuries, and the rider of the vehicle has given the complaint, that is Exhibit P1, wherein he has categorically mentioned about how the accident had taken place and the involvement of the vehicle. Basing on some entries in the medical record, the court had disbelieved the case for the claimant. He submits that the court below ought to have looked at the police records also, which are at the earliest point of time. It is submitted that the court below, more on a hyper-technical approach, had dismissed the claim petition. The claimants are medical students, and the injuries that are sustained by them had lot of impact on their future, and the court below ought to have considered the case of the claimants. Land counsel appearing for the insurance company submits that immediately after the accident they were taken to Jalapa's hospital, wherein it is mentioned that there is a skid and fall from the bike. he submits that even as per the IMB report, the no damage is caused to the tractor, but there are damages to the bike where the petrol tanker and what else? Right down.
Where we read
It is submitted that had the cause of as stated by them, if that was the cause of accident, the pillion rider would have lost his life in the accident. He submits that and even after the accident, they have gone a long way. How many kilometers you said? 16. You said some one side of east to west or something you say. After the accident, nearby hospital, no. Which is how long it is? Jaladi Hospital, which is a nearby Jalapa, which is a nearby hospital. They got discharged from there and went to a hospital which is 100 kilometers away in Bidadi, which is, and in the cross examination, the PW2 or 1, PW1 has stated that the hospital belongs to his father. Land Council submits that all these circumstances clearly shows that it was a skid from the bike, and for the purpose of claiming the compensation, they have implicated the vehicle, and the court below had rightly dismissed the claim petition. Having not heard the counsel on the side, that was the entire material on record. The whole dispute in this case revolves around the fact, revolves around the police record and the medical record. As per the medical record, Wilson skid from the bike. And as per the medical police record, the accident had taken place at on 7/10/2008 at 11:30 a.m. And a complaint was given to the police on the same day at 1:45. In the complaint, the rider had clearly narrated about how the accident had happened and what is the vehicle involved in the accident. When it comes to exhibit P6, what is that? Exhibit P4. Not P4, about the wound certificate. As per exhibit P5, it's a skid and fall from the bike. And the claimants were examined at 2:30 p.m. on the said date. And the same entries were continued in the other medical records. Generally, the courts give more credence to the medical evidence because that evidence is at the earliest point of time and immediately after the accident was as the entries were made, more credence is given to the medical records. In this case, even before the entries are made in the medical records, the police record is the entries in the police records are of the earliest point of time. Hence, in this case, more value should be given to more credence should be given to the medical record, to the police records, where the involvement of the vehicle was mentioned. even the as per the motor vehicles report, MV report, the damages to the vehicle also supports a case of the claimant wherein the offending vehicle has hit the two-wheeler from the backside. And the injuries also that are sustained by the claimants also supports their case. In view of the above discussion, this court is of the view that the court below had failed to appreciate the evidence on record in its proper perspective. Accordingly, as far as the involvement of the vehicle is concerned, there is no the involvement of the vehicle is concerned, considering exhibit P1. This court has no hesitation come to the conclusion with regard to the liability of the insurance company and about the compensation. This court deems it appropriate to set aside the award and remand the matter afresh to the court below. Remand the matter to the court below for fresh consideration. The MACT shall give a reasonable opportunity to both the claimant as well as the insurance company to adduce the evidence only with regard to the quantum and the liability of the insurance company. As far as the involvement of the vehicle is concerned, which one? No, both. No. Evidence will be given to both of you opportunity. No. Quantum and liability. I said liability also. But as far as involvement, what has been decided? Involvement of the vehicle. That is concerned, nothing to be proved now. As far as the, what was that?
City shall give a fresh opportunity and reasonable opportunity to both the parties to produce
To adduce evidence only on quantum and liability. And the party shall appear before the MACT on November 15. It's in Bangalore. 2nd November then. 2nd November, without further notice, and the court below shall the MACT shall decide the same within a period of 6 months from the date of the 2nd November.
Records may be sent forthwith, my lord. The records
shall be sent. In all the cases, it will be there. Thank you. Accordingly, both the appeals are allowed. Okay. Serial number 19. Yes. Now let's see, what's the date of accident? 1810. What was the time of accident? 10:45 p.m. Complaint was given when? 19/10/2008. At what time? 12:30. And what are the vehicles involved in the accident? What are the injuries sustained by the driver of the vehicle if it is from the opposite direction? Rider of the vehicle. No. If the vehicle dashes from the front, the
Both have sustained leading grievous injuries.
both the pillion rider and the rider. No, let us first see. Now this claim petition is dismissed. Or insurance company was exonerated.
This particular vehicle is not.
So, as per the medical records, you stated that auto rickshaw was involved. No, it says the accident occurred when he was proceeding on service to an auto rickshaw. Responding to his vehicle not at all involved in the accident. Injuries to the false charge by the driver of the lorry. The court has only looked at the medical.
Yes.
You have examined any other evidence, witnesses?
From the hospital,
Even?
59. Immediately after the accident. 45 years after the accident. It's not in exhibit 59 that.
Medical College Hospital, Bangalore, MLC. Now, in this, why don't even they mention that where this is exhibit 37? Where did you get? No, what is happening? I don't understand. How many times did you tell them? These are all P9. You are referring to P9?
I am. In an older taxi, urban park. That it is mentioned, alleged history of it by an auto rickshaw. When he was riding two-wheeler, the appellant before this honorable court is riding the two-wheeler, whereas his case is that he is a pillion rider. And the vehicle was just about to move ahead at the road signal. That is mentioned in exhibit P9. And because immediately after about 45 minutes after this accident, this has been mentioned. Therefore, the tribunal has rightly believed the version, the statement made in the exhibit P9. And also,
where did you get the time? From 9:30.
in the doc itself it's mentioned.
It's 9:30. And some, it is exactly there is a punch.
That is there 1910-2008. But sorry, 1810-2011-30. It is 1910-2008, 12:50 AM. Immediately after 45 minutes after the
No, on the left side.
the top is mentioned.
8:10 to the at 12:15 AM.
Yes.
Accident is at 10:45.
It's mentioned as 11:30 PM.
And this is exhibit P6.
P9.
P9. Then what are the other records?
The other records are, it is, this record is summoned by the petitioner, claimant. That is, the record keeper has produced it. Exhibit P8 and P9. The case sheet is produced. That is his document only. And also, one Manjunath, as per FIR, one Manjunath was the rider of the two-wheeler. And he has given the information to the police. But in the Mahajar, if he doesn't find a place, he has not shown the place of the accident. Only some other person by name.
Charge sheet is filed against the lorry,
Yes,
driver of the lorry.
It is not been produced before the ILR 2009.
No, anyway, citation is not required for that.
Clearly mentioned that because the driver is guilty.
That's not a ground.
Is by the classified road. The documents have to be taken into consideration. And he has not examined any other person.
No, why did you know the medical evidence which you produced is against you?
Yes, that one.
Where?
Yes, it has been written by the
Exhibit P?
6.
Let's see.
Then by another case, it is
P5 with P6. The history of road traffic accident. Where will you get the lorry? Here?
by another vehicle. By another vehicle, there is no mention of lorry.
No. History of road traffic accident.
It's not mentioned that lorry has got the accident.
Show it to him.
We have in 2008. Not
In exhibit P6, it's not there.
P7 also hit by another vehicle accident.
Sometimes corrective reading. Yes.
When they accept something that
Please come. There's an appeal filed with the claimant. agreed with the word passed in NSC number 1604 of 2019. Agreed by dismissal of MBC number 1604 of 2009, dated 16 November 2011. The claim petition is filed seeking compensation of, give the record also, claiming compensation of an amount of rupees 5 lakh for the injuries sustained by the claimant in the accident. The case of the claimant is that on 18/10/2009 at about 10:15 p.m., he was proceeding as a pillion rider in a motorcycle along with his friend Manjunath, the rider of the motorcycle. At the time, one lorry came in a rash and negligent manner with high speed and dashed against the motorcycle of the petitioner. Due to the said impact, the petitioner and the rider's motorcycle fell down and sustained injuries. Immediately, petitioner was shifted to the nearby hospital and then to St. John's Hospital, Bangalore, wherein he was treated as inpatient from 19/10/2008 to 20/10/2008. And he has spent huge amounts for the treatment and sought for the compensation. The tribunal had dismissed the claim petition on the ground that, as per Exhibit P9, is it P9? As per Exhibit P9, it is mentioned that the accident had taken place, and that the claimant is a rider of the vehicle, and an auto hit the claimant and he sustained the injuries. And the court below, considering the medical record, which is at the earliest point of time, had held that the claimant had failed to prove that about the involvement of the vehicle. And the case of the medical records do not corroborate with the case of the claimant, and accordingly dismiss the petition. And counsel for the claimant submits that immediately after the accident, the accident was at late night at 10:45. Next day around 12:30, they gave the complaint. In the complaint, they have mentioned about all the details. He submits that just because an entry is made in the medical record about the nature of the accident, that itself cannot be a ground for the tribunal to dismiss the claim petition. He submits that the tribunal failed to appreciate the evidence on record, and counsel appearing for the insurance company submits that in the complaint as well as before in the claim petition, it is a consistent case of the claimant that he was a pillion rider and a lorry hit them from behind. The lorry came in a opposite direction and dashed against the vehicle. He submits that the medical records which are produced by them, that is Exhibit P9, shows that an auto, because it's an accident between the vehicle which the claimant was riding and the auto rickshaw, which falsifies the case of the claimant. And rightly, the tribunal had dismissed the claim petition. I mean, here the counsels on either side, there was entire material on the file. The medical records, which the petitioner was admitted in the hospital immediately at 12:15. He was at 10:15 in the hospital. Therein, it is mentioned about the involvement of an auto and the petitioner riding the vehicle. In the case of the claimant that a lorry hit the vehicle and that he's a pillion rider, is contrary to the medical record. And though the police record supports him and the claimant has the rider of the lorry, the driver of the lorry had pleaded guilty, but that alone cannot be a ground to disbelieve the case of the claimant. And he filed an petition under 166. He has to, by using the evidence, he has to substantiate his case. Hence, in your the above discussion, this court is of the view that the tribunal had rightly dismissed the claim petition. Accordingly, appeal is dismissed. Next.
Number 20, Mahesh.
Serial number 20? Yes, Mr. Mahesh.
Appear for the appellant.
Yes, you are on liability or on quantum?
On the liability, my lord.
Yes. How much was the claimed amount?
My lord, one submission. So it is a claim under 163A. Whereas tomorrow the same point is before your lordship. My lord, I will argue on that case along with this case. My
Why
lord, that is what,
you argue your case independently?
my lord, what happened in this case is, my lord, actually I have given no objection. Yesterday only, but they are not engaged in a service of any advocate. Thereafter, my lord, I again contacted O. Mahesh, advocate, my learned friend, and get all the documents. And it is not yet taken the printout. Fax is also not, that's what tomorrow, my lord, only 24 hours. Tomorrow. Only for that, I will take out the printout today. Tomorrow, my lord.
From morning, this is the third request from you.
That is why whenever I am facing difficulty without the materials problem, but I will.
No. For a 2012
see,
you
Shastri,
shouldn't have any difficulty court cannot entertain.
my
That you
lord,
have to take care of
that
it.
is correct. That is correct. My lord, but Shastri never asked the adjournment.
No.
My
Mr.
lord,
Shastri asks for adjournment very often.
No, my lord.
At least once in a day. Next matter.
The point, but
Tomorrow.
Oh Mahesh know me very well from 30 years. I never asked adjournment. But it's the old matter, son.
But the court is saying from 2 months experience.
But
You might be having more experience, I don't know.
Yes, they have the 30, they are struggling with
All the
this.
next matter, it will come tomorrow. Next.
I appear for respond number 2 insurance company.
Yes. What are your instructions?
My lords, this concept of cover note is new to me as well. Therefore, I had some hiccups while arguing the matter.
No, the issue is not about the cover note. It's about your agent and your relation and his fraud. How the claimant has to answer to that.
My lords, this is not a purely principal and agent relationship that we are looking at. This is the fraud played by the automobile dealer. Cover notes are available with them as and when vehicles are sold.
He might have played the fraud on you and them, and you engaged him, so you bear it. Why should they bear it?
No. Now, if tomorrow this person goes and commits a crime, I cannot be held responsible.
You should be held responsible because you're the principal.
No. The dealer is given the cover notes. He has the printed book with him. As and when vehicles are sold.
No, 5, that is 5th, the date, the month, I don't know, I don't remember. On that day, he gave the check. Check was given on 5th.
Check was given subsequently, my lords.
No. Check date was 5th. How do you say it is subsequently? He must have presented it some other day.
Unless the premium has reached the company, we cannot assume any contractual liability, and that is what section 64 VB of the Insurance Act also says. Now the check may be 5-7.
So what is the purpose of giving the cover note? Please tell the court. You have taken a check subject to realization. After 30 days, that will follow your policy. Come to the court tomorrow. You are not audible.
Now it's audible, man. Now it's audible. Yeah. In the meanwhile, there was some disturbance in the video. The cover note was antedated. The check was forwarded 1 week after the date of the accident. Until then, no intimation is received by the insurance company with regard to this cover note or the check. No premium is realized. The cover note has not formalized into a policy of insurance. Therefore, I would ask myself, where is my contractual liability to indemnify the insured?
You accept that the cover note was a certain lease or is given to your that the showroom person,
All
he
dealers.
in turn has issued it to the customer. According to you, there is some fraud paid by the first respondent, that is a showroom person. Now, for you to say that he has not given the check on 5th, as on the day when a cover note was given, what is the material?
My lords, in that regard, I am handicapped because I do
Every
not
time
have
you
the.
can't ask for a time like this. Ask,
No, no, no.
please ask you, either you come to the court or ask your colleagues to come. This can't go on tomorrow. Yes, next.
I'm sorry, in that regard, I do not have the documents with me. I'll have to collect it from the
That's
company.
why. No, you don't collect anything. Everything would be in the court record.
Right. I'll be there
Then
in the
post
court.
day after tomorrow. At the request of land counsel with respondent, post day after tomorrow. No further adjournments. Yes, next.
22 and 23 adjourned. Serial number 24. FTT.
You are referring to the respondent. Yes. On what ground? Which term? What is the term? Pay and record was ordered. Was ordered?
No, not.
Will order.
Then this concept
Yes.
was.
Now, what about the compensation?
Compensation.
Yes, let's see. Let us read together that compensation aspect.
80,500.
Let us read issue number 3.
People have come to the student training for the one. By
So, 1, 2, 3. 3 fractures.
radius, tibia and fibula. Tibia and fibula is. So both are of the left leg only.
So, 2 fractures.
It's also applied by the doctor and it is the previous disease. Coming to the disease, that they have been on the line, will not mind from 8 to 10, 18,
How many days?
70 days. Here the petitioner has stated that due to pain, he was not able to walk without pain. There is no one in regard to the increase in pain. That's why no document that is attached to the 45,000. The petitioner has stated
No, towards conveyance, transport, and nourishment, grant 20,000. Under 3 heads. Next. In which case? Oh, looking at the kind of. No, looking at the injury and the time of hospitalization and the recovery, what is the attendant, the support he required, all. Yes, it is not just about 2010. Next.
The medical, because then the compound system is awarded.
Yes.
Then
Next. So here it is granted 2,500 attendance charges and 2,000 towards the conveyance. Put together it is 4. No. Put together 2,000 plus 2,500, 4,500, and extra nourishment was not considered. So for that, the altogether put together 10,000 is granted. Yes, next. Medical bills.
Medical bills is 30,000.
31,410. Yes.
30,000 that driving has awarded.
30,000.
It's
Hmm.
a continuation petition itself, he was working in electricity. That is. The document.
Court had taken 3,000, we'll take 4,500. Ramchandrapa's case,
In the year,
that is much fair. Huh?
As per the chart, it should be very.
This is which year? 2010. 2010, it would be 5,500. No, why? You only wanted legal service authority. 4,000, a loss of income during laid up period. $4,500 into,
3 months the driver has.
it would, 4,500 to 3 would be 30,500. Next head,
Because he has not examined the doctor also.
legal agony, conveyance, attended, mental, legal expenses, 10,000.
They not examined the doctor.
So now the payments offering 60,000, conveyance, transport and nourishment 10, medical bills 30, loss of income during the later period 13,500, legal expenses 10,000. Comes to 1,23,500. Is an appeal filed by the claimant, agreed by the award passed in. Let's see whether the condition was unknown. No. That would be there in the order itself, whether it has, it is entitled for interest or not. She says it's unknown without any condition. It's an appeal filed by the claimant, agreed by the award passing. MBC number 718 of 2010 dated 23rd September 2011, whereby the insurance whereby the court, the tribunal, so granted compensation of an amount of rupees, how much? 88,500 has exonerated the insurance company and held that the owner alone is liable to pay the compensation. The case of the claimant is that on 2/3/2010 at about 5:30 p.m., the claimant was standing near Mudina Bani Masjid Road in MB Muda village on a footpath in order to catch the bus. At that time, one auto rickshaw came from Old Bridge side towards PC Road side, driven by its driver in a high speed, violating the traffic rules. And due to the overspeed and the negligent driving of the driver of the auto rickshaw, he lost control over it. And he came to the footpath and dashed against the claimant. Due to that, a sustained fracture of left radius, fracture of shaft of left tibia, fracture shaft of left fibula, and other injuries all over his body. Immediately was shifted to Muller's Hospital, Bangalore, and was an inpatient from 2/3/2010 to 18/3/2010. That is for a period of 17 days. The court below, and he has spent a lot of amounts for the treatments. The court below, on the issue of liability, has held that as there is violation of terms and conditions of the policy, that is, that the driver of the auto rickshaw has violated the conditions of the policy by plying the auto rickshaw in the town limits. As he has a permit to ply within the rural limits of the Pantwala, but he, as contrary to the terms and conditions and contrary to the permit, he had applied the vehicle, and as a violations of terms and conditions of the policy, insurance company is not liable to pay the compensation and held that it is the owner alone who is liable to pay. When it comes to the compensation, the court below, considering the practice sustained by the claimant, had awarded an amount of rupees 45,000 towards pain and suffering, towards conveyance and attendant and nourishment 4,500, medical expenses 30,000, loss of income 9,000. Altogether, a compensation of rupees 88,500 was granted. There is no representation on behalf of the appellant. Then counsel for the respondent insurance company is present. As this is an appeal of 2012, this court has not inclined to adjourn the matter and proceeding and inclined to proceed with the testing on the material available on record. In support of the grounds of appeal, it is stated that under the head of pain and suffering, granting an amount of rupees 45,000 was on the lower side. The tribunal ought to have taken the income 6,000 as he was an electrician, but the court had taken 4,500. Further, no, it should have taken 9,000 according to him. Even under the heads of transport, conveyance, and extra nourishment, the amount that was granted by the tribunal was not reasonable. Further, the tribunal ought not to have exonerated the insurance company when just because as there are violation of terms and conditions of the policy, when the claimant is a third party to the contract of insurance. On the contrary, learned counsel for the insurance company submits that as he was flying the vehicle contrary to the terms of the permit, the tribunal had rightly exonerated the insurance company. Even otherwise also, learned counsel submits that as there was no evidence on record with regard to the injuries, treatment, and other things, the court below has already granted a reasonable amount and no grounds are made out seeking enhancement of the compensation. Having heard the learned counsel for the respondent, there was entire material on record. First coming to the liability, the only ground on which the insurance company was absolved from the liability is that as per the permit conditions, he cannot enter into the town, and beyond the permit as he was flying the vehicle, and it amounts to violation of terms and conditions of the policy. Insurance company is not liable to pay the compensation. In the light of the settled law, in the light of the law laid down by the Honorable Apex Court in Swarensing's case, still the insurance company is liable to pay the amount and recover the same from the owner of the vehicle. Hence, the insurance company shall pay the compensation and recover the same from the owner of the vehicle. From the owner of the vehicle, whoever it is.
Both the owners have been, as per the RC, there was no change, but I think that's the person who. Therefore, the court did that as per the record.
Second. First one is
another owner, that means he had actually sold the vehicle, but on records, was second respondent.
And second respondent, owner of the vehicle. Then coming to the compensation, he had sustained 3 fractures and he had been in hospital for how many days? 17 days. And the pain and suffering he had undergone, this court is inclined to grant an amount of 60,000 towards conveyance, transport, and nourishment. Court below had granted only an amount of rupees 4,500, and as considering the injuries the duration of the hospitalization and the recovery time, this court is inclined to grant 10,000 towards medical bills. Court below had granted 30,000 and no interference is called from this court. And towards the income during the later period, this accident had taken place in the year 2010. According to the complaint claimant, he is working as an electrician and earning an amount of rupees 9,000. Court had taken 3,000 as an income. Applying the ratio laid down in Ramchandrapa's case, this court is inclined to take 4,500 as the income, as it would take minimum 3 months for him to get back to the work. Under the head of loss of income during the later period, is entitled for an amount of rupees 13,500. In the light of the law laid down in Mekhala versus so-and-so, towards legal expenses, they are entitled for an amount of rupees 10,000. Altogether, the claimant is entitled for an amount of rupees 1,23,500. Accordingly, the appeal is allowed, enhancing the compensation from 88,500 to 1,23,500. The enhanced amount will carry 10% interest. 6%, sir. 6% interest.
Entire amount and I have to pay it 6%.
And the insurance company, yes, insurance company shall pay the amount and recover the same from the second respondent.
Entire amount 6%. First, driver I have not paid because I was.
Entire amount, yes, entire amount 6%. Generally, like whenever enhanced, entire amount 6%. Next.
Number 25, Janardhan Reddy.
My lord, I'm for the respondent. I humbly pray for some time, my lord. My senior has gone to attend an medical emergency.
At the request of the counsel for the respondent, post these matters are.
Yes, ma'am.
Earlier also you made a request.
He was not well, my lord. Dengue bandu, he was recovering. He was about to attend, but relatives would be serious like the medical.
Watch the proceeding, something against your client, then we'll adjourn the matter. What is it? Yeah. And what was the exit? It is?
Injury claim.
It's a case of injury. How much was the claim?
Maybe 1 lakh plus.
How much was granted?
About
18,000. On what ground you are denying the liability?
The medical was not involved in the accident. But if you look into the statement, question, large person, the director, but on the accident, they are not produced, they are not in complaint. There is no FIR. There is
no. When is the complaint? When is the accident? 14 to 2003 at what time?
At 7 p.m.
7 p.m. They have not lodged any complaint.
No
They
complaint.
didn't go to the hospital.
The hospital records, they are not produced, the ML's records also, ML's records also not records. There is no charge sheet, no IME. Only no police complaint, no FIR.
Witnesses?
Witness that the petitioner was injured.
No.
And other 2 doctors were examined by the petitioner.
Doctors.
Doctors. And one of the investigator committee is the third respondent hearing. He was the driver of the motorcycle.
What he said?
Yeah, I was driving the motorcycle at the time he was a clear rider. The vehicle belongs to petitioner's husband only. The second respondent is the husband of the petitioner, first respondent.
Then we will post this for judgment on Monday. Heard the learned counsel for the appellant in part at the request of learned counsel for the respondent, post this matter on Monday for judgment. That day, no accommodation.
Yes, yes, my lord.
Yes, next.
Number 26. P. Ravishankar Shastri.
Common order. What are the number? No, MBC.
160, 2009. That's case of death, my lord. Whereas MFA 104.
He's the rider of the vehicle. Huh? And what is the corresponding appeal? No. MBC 1610 is the case of death. What is the corresponding appeal?
MFA 1040.
MFA 10,420. So that bit is a number.
10,418 case.
1 minute. Next is the injury case.
Yes.
MBC is
MBC 1611 of 10. Corresponding.
11 of 9.
Yes.
Appeal is
MFA 10418 of
41
8.
of 12. How much is the compensation claimed in case of death?
Case of death, my lord, the compensation claim is 10 lakhs.
How much was granted?
7 lakhs.
7 lakhs. And in case of injuries,
50,000 was paid.
why very reasonable amounts are claimed?
4,500.
No, even in the case of death also 10 lakhs. 50,000, how much was granted? 4,500. Now, the insurance company was held liable. Applied. So now coming to the compensation. You agree on that?
That is relatively wrong. That is relatively wrong.
Yes.
There is no the driving license. That's for the driving. When you see the data, the driving license is expired.
Then we'll say pay and recover. We'll say pay and recover. Either way, whether it is no, for you, whether it is Mukund Devagan or Saranthi, you are not bothered. Ultimately, you want it's for the owner to feel. 19 level.
2003 to 15/3/2020 non-transport driving license.
What was the vehicle?
Vehicle as per the direction tempo under
Whose tempo was the vehicle we was driving? No. Why are you saying that there is no driving license at all?
You will not make anything. FDL, private light model, 1911-2000. Minority got the penalty. The first right thing that one passport. This is like from 2004. Applies to drive transport operation. Very happy for me. Taking into consideration with her.
Tomorrow for judgment.